establishing a criminal penalty for the theft of a public servant. We have the prime sponsor, Representative Love. Yes, my bad. Okay, wait, I don't even have the bill. Oh. Representative Cochran, I'm sorry.
No problem.
Please accept my apology.
Chair and committee, thank you for your time. I'm the sponsor, and this is my freshman session and my second bill, so please bear with me if I make any small mistakes. My name is Travis Corcoran, and I'm the sponsor of this bill. The problem. In theory, New Hampshire town government is open and fair. In practice, while sometimes true, it is also sometimes secretive and biased. From discussions both with constituents and with multiple lawyers, the problem of town boards that engage in self-interested governing or casually violate citizens' rights to open government is a widespread one. As a citizen, I have read dozens of New Hampshire court cases and rulings arising out of town boards engaging in conflicts of interest and illegal secret meetings or communications. This is out of the hundreds of such cases that exist, and that in turn is a small subset of the happened. Very few citizens sue when their rights are violated, as lawsuits are very expensive, tedious, and stressful. Sometimes town boards do not merely deliberate in illegal secrecy, but actually purport to make decisions and authorize expenditures in secrecy. Because they know that they act in secrecy and that their deliberations and votes will never be made public, they're not constrained by possible repercussions. If an action taken in a secret meeting is later revealed, no one need admit to voting for it. Was the decision made 5-0, 4-1, 3-2? Was there actually a majority at all? Was a vote even held? There is no way for anyone but the board members themselves to know. The current incentives are effectively heads I win, tails it's a tie. RSA 91A provides that citizens may sue to illegally hidden public information. But there's no remedy if a citizen discovers that actions or decisions had been made in secrecy. There may be no minutes or votes kept, so merely mandating the release of non-existent records does nothing. Expenditures authorized outside of legal meetings cannot be clawed back. Judicial actions authorized outside of legal meetings likewise cannot be undone. Further, the incentives for board members suffer from the principal agent problem. If they conduct a secret meeting and authorize expenditures, in the very worst case, for the board members, a citizen will sue, innocent taxpayers will defend the behavior that the board took in court, and if the board loses, then innocent taxpayers will pay a second time, paying the plaintiff's legal fees. The pain of misbehavior under current law lands entirely on the innocent, and those who broke the law suffer zero consequences. Thus the need for this bill. A board member who has a desire to violate the state constitution and the law may not blink at doing so when he knows that he is entirely immune to personal repercussions, but is much more likely to take the rights of citizens seriously if there are possible penalties that would affect them. The political option is theoretical but not realistic. In many towns, various boards are appointed, not elected, and so are not responsive to political process. A concerned citizen who is upset that a board had, done such a thing, authorized expenditures in an illegal secret meeting, would first need to propose a warrant article, get sufficient signatures on the petition, win at the polls with the warrant article, convert the town to elected zoning or planning or whatever other board might be relevant, and then run additional campaigns to place public-minded citizens on the boards. And even then, harms already committed cannot be undone, and new board members serve under the same flawed incentives as the old board members. This bill is complementary to RSA 91A. RSA 91A lets citizens attempt to recover illegally classified information. This bill provides penalties for actions taken illegally outside of legal meetings. Finally, economy. This bill addresses a real problem experienced by citizens in towns across New Hampshire, is narrowly targeted, imposes no or minimal costs on towns, directly addressed at the state level via legislation, not at a town level via the political process. The best law is one that causes correct behavior by well-tuned incentives. This bill, by making board members be aware of and face some small penalties for egregious violations of ethics laws, would improve life for countless New Hampshire citizens, reduce the number of lawsuits choking our overworked courts, and thus reduce costs on the state, and impose minimal or no costs on the town. And that's the end of my prepared testimony. I've submitted this online, but on the drive here, I thought of one illustrative example to explain, the sort of scenario. If we have, for example, a parent who has a child with autism or some learning disability, there might be state regulations mandating that the town provide special services. And of course, the town is, free to not do that, in which case citizens would have to go to the courts and argue for it. And the town government, in turn, has to decide whether it would defend that lawsuit. They might, their two options are basically the Board of Selectmen can meet and say, yes, we just don't want to pay for this. This parent is entirely wrong. and they are allowed to do so in closed meeting. And that's entirely appropriate because you want to have the legal strategy. You don't want the opposing party to know that it was narrow or that they had this one concern, and then the opposing party could, sort of target that. But closed meetings, especially of this type, are run as meetings and should have a vote and should have minutes. And then at the conclusion of the legal matter, those closed meetings minutes and votes are made public. The issue specifically is that in such a case, the board might decide to meet and not even call it a meeting. They might meet in a coffee house or something and say, yes, this is certainly worth $25,000 from the taxpayers to defend against this parent trying to legitimately get the, rights for their children. And if the parents, then win, finally they get the special classes or the teacher's aide or whatever that state law mandates. At this point, the lawsuit is over, and the citizens of the town would like to know, hey, we just, we, the town government, just violated this parent's rights, and then we went to court a second time to try to insist on that violation. Who exactly made this decision? Who authorized the expenditure of $25,000? And, this is a best case scenario. There could be multiple cases. It might get appealed up to the Supreme Court. There might be follow-on cases. So you could end in a situation where $50,000 or $75,000 of citizens' funds have been spent in, sort of defending these lawsuits. And this is exactly why the political process is open. You want to know retrospectively, who did this so that we know whether we should vote for these people in office a second time. And you also want prospectively the board members to realize, hey, the votes that I take about spending dollars, I will be accountable for. It will come out eventually. And under current law, it is wrong to have such a meeting and authorize expenditures, but there is absolutely no way for citizens to do anything about it later. That's the conclusion of my testimony, and I'm happy to entertain any questions.
Thank you. I just have one question, if I may, on something that you had just mentioned, and I'm wondering if I'm confused or if possibly if I heard what you were saying incorrectly. You had mentioned the example that you just mentioned. When I'm not playing politics, I do work in a school, and I work in the special education department, and it sounded to me that the example you were given was a school, more of a school situation, not an actual local municipality. We have the school board.
Right.
God bless you. And then, of course, we have our board of selectmen.
Right.
So was that your intention to discuss
my
a school
intent there
situation, or did
was-
I not hear it correctly?
That was a good question, and thank you for it. As I mentioned, that was an example that came to me to sort of concretize it as I was driving, and I didn't get the chance. But we can supplement that with any other example where if we wanted to make it a zoning issue, where a zoning board of appeals authorizes a body shop in a residential area, and then the citizen wishes to appeal that, goes to court. And the Board of Selectmen, for example, in the scenario, might have a secret meeting. And so, the citizen in the end might win, say, yes, that was an illegal zoning decision, it was made improperly. And we say, this was such a slam dunk. The BOS, made a really silly decision to authorize expenditure of $20,000. Who exactly did that so that I can keep that in mind when I go to the polls?
Thank you. I like that example much better.
Wonderful.
Are there any questions from anybody in the committee?
Yes.
Representative Muse?
I notice in the bill, there's liberal use of the word theft.
I'm sorry, I can't quite hear you.
Sorry about that. In the bill, in the wording of the bill itself, you use the word theft pretty liberally. And in New Hampshire, theft typically has a criminal penalty. This bill has civil penalties. Curious about your use of the wording and why it appears in here.
Again, I missed the one critical word because a door was opening, but I think I can answer it even having missed the word. This was drafted by OLS, and I depended on their help. I would absolutely be amenable to changing the wording to make it in keeping with the intent. Thank you.
Representative Selig?
Thank you. I'm sorry that I apologize that I'm going to phrase this awkwardly. I'm still trying to formulate how to make this make sense. So if I understand this correctly, if, for example, Joe the plumber goes to the planning board and asks them to create a legal zone for him within his district, to rezone his house so that he can have his plumbing trucks all be parked there where it would not otherwise be. and they approve it, and then his next door neighbor goes to the, sues the planning board for approving that decision. And the planning board then hires an attorney to defend their decision. Is it your premise that that's theft, that they're, I'm just trying to make sense of,
I think I understand the question and I can speak to it. So that was excellent. That's a perfect example. Currently, it is absolutely illegal, and under this bill would absolutely continue to be legal that the Board of Selectmen would authorize a defense of that, and win or lose, that's fine, and that would not be made theft under this bill. It is entirely reasonable that a board might say, "Hey, we acted in good faith. This is our understanding of the law. We consulted with an attorney. The attorney said, yes, that is reasonable." This law specifically addresses if the Board of Selectmen, instead of doing this properly, going into a closed meeting, discussing it, perhaps taking advice from an attorney, and then voting 4-1, saying, yes, let's defend this lawsuit. That is currently legal and would remain legal. The scenario that this bill addresses is when the Board of Selectmen meets at one selectman's house, not recorded, not an official meeting, and says, we need to have the secret meeting because we all know what's wrong. We all know that this defense is really iffy. It's a Hail Mary pass. Probably the guy's going to win. But, Joe the plumber is my cousin. He's your, high school friend, etc. Let's do this solid for him, at least show that we're trying. And, then if we lose, at least no one will know that we voted for this expenditure.
Recognize for follow-up.
thank you. So my understanding of the way town ordinances and New Hampshire law is, and again, I'm not an attorney and I'm also new to all of this, but is that secret meetings are actually explicitly prohibited by law and statute, in which case they would be acting outside the purview of their committee, which would not then give them protection. So I still don't understand why this would be necessary. It seems to me to be, I'm just trying to, sorry, I need to
That's
stop
an
right.
excellent question, and that question speaks to exactly the intent of the bill. It is illegal to have a secret meeting, but the question is, what are the incentives on the board? If let's say that they choose to have that secret meeting, and they twist their waxed mustaches and say, "Yes, we're all gathered together to do something villainous here. We know we're breaking the law, but still, we all agree that let's have the secret meeting. Let's authorize the town attorney. Let's pay taxpayer dollars to do Joe the plumber a solid." Now, let's say that happens and a check is written, it's handed to the attorney, the case goes to court, the town either wins or lose, and then a citizen, says, "Hey, I have read RSA 91A. I know that closed meetings are legal, especially in this particular case, but that minutes and vote totals must be kept, and those minutes and vote totals must be released at the conclusion of the lawsuit." So great, the lawsuit is over. I would like to see so that I can vote for people who are making good decisions and vote against people who are making bad decisions. I would like to see that vote total, please. Please show me the minutes. And the answer is, lol, there are no minutes. There's no vote total. You don't get to know what we did at that illegal meeting. The only remedy under current law is that a citizen can sue under RSA 91A. They can, reach into their own pocket. They can pull out $10,000 or $20,000. They can go to court, and they can win. At which point, the judge will say, "Board that had this illegal meeting, please hand over minutes, if any, of your decision, and minutes, if any, of the meeting." And the board says, "Okay, we understand, but there were no minutes." At this point, the money, the taxpayer money, has already been spent. The lawsuit has already taken place. The citizen who had to, prosecute the underlying lawsuit, is out of pocket. So just because something is illegal doesn't mean that there's any incentives to stop the board from doing it. And that's exactly what this is attempting to patch.
Thank you for taking my question, and thank you, Madam Chair. I was under the impression that vote totals and minutes weren't kept in non-public sessions. Is that the case?
That is not my understanding.
Okay.
I believe, and I don't have the clause at hand right now, but there is a clause in RSA 91A. It's the third or fourth paragraph, and it specifically says that in the case of closed meetings for the purpose of defending a lawsuit. So we might both be right in different subsections. So, for example, if it's a closed meeting to decide, what should we do about the police chief? We think that he's hitting on employees. I'm not sure if minutes and votes are kept for that, but I am quite convinced that they are kept for decisions about engaging in lawsuits, and it is explicitly the case that they must be released after the conclusion of the lawsuit.
So to answer that, they keep very, very vague minutes for any kind of non-public, and I do believe that they do keep votes, and then in the event that they're ever unsealed, then they have the information, but they're very, very vague. Representative Muse?
Yes, so I just want to stand corrected in the bill. The bill references RSA 63711, and that specific part of it, or the applicable part, says shall be guilty of theft by a public servant and subject to the penalties in RSA 63711. For an expense larger than $1,500, that's a Class B felony. So it is not just a civil issue; it is a criminal issue. And for an offense where the sum total is larger than $1,000, it's a Class A misdemeanor. So I guess my question for you is do you think we should be criminalizing the behavior that this behavior rises to, number one, to a criminal behavior, and do you think that this penalty is appropriate for volunteers?
That is an excellent question, and I would say that on the one hand it's volunteers, but on the other hand it's a paid position. But the intent here was not specific penalties. In general, we set incentives or penalties not because we want to collect them, but because we want people to be aware that there is a hard line that they shouldn't cross. So, for example, we had a road that doesn't have a speed limit on it. We might choose to put a 50-mile-an-hour speed limit there, not because we are hoping to get lots of fines, but just to make aware what the boundaries are. And then ideally we would hope that we never once catch anyone breaking it. That's the goal. The goal is not to punish people. In my ideal version, this bill would be passed and then it would never actually result in anything. Speaking specifically to the size of the penalties, much of what I'm aiming for could be accomplished just as well with a $500 penalty as a Class B felony or something. I again depended on OLS and probably didn't express my intent crisply to them. I would be happy to amend this, and I would love to hear any feedback about what would seem to be an appropriate level of penalty that expresses the intent of the law and the importance of having open and responsive government without, certainly holding 10 years in jail or $50,000 fine over somebody.
Thank you.
Thank you.
Are there any other questions from the committee? Representative Newman?
I apologize for being late, but you can see the reasons why out the window. I have some confusion. It sounds like there may be criminal penalties, but it looks like the entire section of Section 2 is that any citizen can take action, and you may have said this before I came in, and I apologize if you did. It sounds like they can take it to court and then get some kind of remuneration for that and whatever. So at least partially, even though it falls under something that has a criminal penalty, this is like one of some of the laws that have recently been passed that takes this kind of thing out of the purview of the courts and puts it into the purview of any private citizen that wants to take a civil action.
That's
So
an excellent
am I
question.
incorrect in that?
Yeah, that's an excellent point, and I again plead I'm an engineer and not a lawyer, so I think that this is something that definitely needs to be tidied up via amendment. The intent to have civil action is definitely on there, so that citizens, just as with RSA 91A, can push for some sort of resolution without having to depend on third parties. But I entirely understand that it is not the purview of private citizens to push for criminal penalties, and so I would like to speak to OLS and come up with something that resolves that. And
Could I have a follow-up?
Recognize.
And in the first part of it, it says, so it's a person who authorizes or attempts to authorize a defense. And I don't know if then it says to pay, they have to pay for it or not. I guess if you have, if, does the person have to be authorized, the person who does the deed of talking about or raising or discussing, it looks like even, a defense or something, uh, I'm just confused whether that person has to be authorized in the organization that he's in to be able to make payments, or does that even factor in at all?
That is a great question. Thank you for it. And I think that this is another thing that I need to work with the OLS on and clarify what the appropriate approach here is.
Thank you.
Representative Prout?
Yep. So I came in late, and you don't want them to defend a member of the town, or?
No, that's a great question. Under current law and under the proposal of this bill, it is absolutely legal for a town to defend against any lawsuit, and they can deliberate on it. They can choose to defend. They can choose not to defend. They can choose to defend to the bitter end, defending it, appeal after appeal all the way to the Supreme Court. That is absolutely reasonable for a town to do, and would remain legal. The problem that this addresses is that sometimes towns know that they have a bit of a stinker of a case, and the individual board members who are in the position of authorizing or not authorizing a defense, might want to spend some money to show a buddy that they're collaborating with, hey, I've got your back, we're going to fight this to the bitter end. But they might not want that to be public later. The best of both worlds, where they're doing one thing, but if citizens later say, hey, we spent $25,000 authorizing this insane thing, we got slapped down by the judge, we the town, who's behind this? Because when I go to the polls in March, I want to make sure that I'm, electing selectmen who are responsible stewards of our tax dollars. Under current law, once a lawsuit is concluded, the deliberations about defending that lawsuit and authorizing the expenditure are public information. However, it is possible for board members to violate that law. They can say, hey, let's not meet at town hall. Let's not turn the cameras on. Let's all meet in my sunroom and figure out what we're going to do about this. We know we're going to lose, but at least Joe the plumber, who's my cousin and your high school buddy, he'll know that we did everything we could. And, sure, it's going to cost $25,000, but it's not like we're going to have to pay that. Right now, that can happen, and then the lawsuit loses, and then the citizen who was trying to, get his child, special remedies, or there was a zoning dispute, or, contracting, says, great, I want to know who spent that money. And the answer is, oh, there are no records. We did it in a secret meeting. And you can say, okay, RSA 91A says that I can get the details of that. And the answer is, we didn't keep any notes. And then he says, and also I spent, to prosecute this lawsuit against you, I spent $25,000. What happens? Do I get that money back? And the answer is, nope, it's done. We just had a secret meeting. We authorized expenditures in this illegal secret meeting, and there's nothing a citizen can do about it. You can't even vote against us next time because you don't know who did it.
Okay, thanks. Appreciate that.
Thank you.
Representative Muse?
But in that example, couldn't the citizen file a complaint that the right to know law was violated in that case?
Absolutely. And this was a question that I think Representative Selig asked earlier. He could file a complaint. And under current law, what happens with that complaint? So first of all, you don't file a complaint under RSA 91A. You launch a lawsuit under 91A. You can then go to court. The citizen can reach into his own pocket, spend $15,000. The judge can say, yes, clearly there should have been minutes. There should have been a vote recorded. It should now be publicized. So, Board of Selectmen or Planning Board, please publicize those minutes. Tell this citizen what he wants to know. Tell him who voted for that expenditure. And the board, smiles at Cheshire Cat grin and says, oh, there are no notes. And the judge says, okay, well, I did what I could. And then the citizen asks, Judge, I spent $20,000 to, deal with the zoning issue or whatever, went to court. They had a secret meeting. They expended taxpayer funds in this secret meeting. Now, there's absolutely nothing. They're saying they don't know who did it. That money doesn't go back to the taxpayers. What do I get, Judge? What do the taxpayers get? And the judge says, sorry, citizen, under RSA 91A, everything that could be done has been done. We asked them to reveal minutes, and they told us there are no minutes. That's the end of it.
Follow up? I understand the the hypothetical situation. What I'm also curious about is whether there's actually any data on how often this happens.
That's an excellent question. I have, knowledge of a couple of times it has happened locally, and that's one of the things that motivated me to run for the House. I have done a lot of lay research, reading Supreme Court, New Hampshire Supreme Court cases, and I've spoken to local attorneys. Um, and the answer is, oh yes, stuff like this happens. But when someone says yes, this happens, and yeah, I had a client up in Milford or in Henniker or something this happened to, that's an anecdote. It's true, but it's not hard data. And I'm an engineer, so I always like hard data much more than a story. A friend told me that his cousin had this happen, so I wanted to walk in here with a list of here are 73 times that this has happened. Unfortunately, there does not seem to be an easy way to get hard numbers on that. Um,
Thank you.
Tech.
Just a quick question. I thought you had to come out of non-public session and for a vote. I didn't think you could take a vote in non-public session.
I'm not sure if that's the case or not, but in either case, we're getting to the exact same thing. Apparently, there is this situation, whether you're allowed to or not, you get into a situation where votes are taken in things that are neither public sessions nor non-public sessions. They are illegal meetings, and expenditures are authorized in those meetings. So, if your statement is, "Wait, that doesn't sound right to me. I don't think they're allowed to do that," I entirely agree with you.
Representative Roy.
Thank you, Madam Chairman. Thank you for taking my question. So is it your position that while 91A exists and dictates what they may or may not do, it has no teeth if they decide we're just not going to follow that?
That's an excellent question. It has 2 or 3 teeth. And so the teeth specifically that it has is, as a citizen, you can sue and say, hey, there may or may not be records, and you're trying to hide them from me. Please give me those records. And if you go through the laborious and expensive and stressful process, and if you win, you can get the records. That doesn't help. So here's one tooth that is missing. It doesn't help if there are no records. And here's the second thing: if actions were authorized, there is no way to undo those actions. So if, to make up a crazy thing, if there was a taking, we decided that we wanted this farmer's field to put in a football field instead, and we did that. And then the farmer sued and we went to court and everything. And we want to know, who is behind all of this? And the answer is, oh, we were very careful to not take any records. So great, you don't get your records. And second, the farmer says, well, can I have my field back now? The answer is no, that's done. Well, okay, can I at least have my, $40,000 in legal fees back now? Nope, that's spent. Can the citizens have the $30,000 that they spent? And the answer is nope, that's spent as well. So there was a question earlier about, do we really want to criminalize and make a Class B felony out of things? And I agree to that. And we really, don't want to have massive penalties. I would not want a law that's going to let some volunteer who maybe got in a little over their head suddenly is, paying $100,000 in fines. But I think that by having some, I don't want to quite say token, but, relatively small fine to make it clear that this is a boundary, that, if you want to take Farmer Joe's field for a parking lot, do it on the up and up, have the integrity to at least have your vote recorded in a closed meeting, so that when it's all done later, that'll come out and, you should be proud of and defend your vote on that. So this is only about sort of egregious cases.
And pardon me for not having had time to read it through yet. I too am a little bit late. Is there any way that the penalties you are proposing would fall back on the taxpayers?
The intent here is specifically not. It is very specifically, because that's the problem it tries to solve. And so, I would hate to say, hey, the taxpayers are getting a raw deal. Let's give them a second raw deal to make it better. So the intent is that this is an action committed by an individual who serves on a board, and the consequences should fall on that. There was, like I said, one question about the size of the penalties, and that's certainly something I need to address. And there was another excellent question about sort of a weird mismatch between civil and criminal, and that also needs to be addressed. But as I work with OLS, I will certainly keep as the core issue, something you and I both agree on, apparently, that these should not fall on the taxpayers.
Representative Newman.
So the last thing I'd like to ask you about is what is an example of or an explanation of who the people are? It sounds like there are two or more people who are on some legislative organization, and they get together, and there's three of them, and two of them say, I think we ought to start a lawsuit, and the third one says, no, I don't. And they say, well, we took a vote and we're going to go ahead with this lawsuit. So they go ahead with the lawsuit, and I don't know whether they win it or lose it. I'm not sure I heard that. But then what happens? The money that comes from the municipality has to be, in my opinion, has to be voted on by the municipality. I don't know how they wiggle their way into a non-session or whatever. How did they do that in
Right.
that?
So this is an
off-site
excellent
setting?
question. Someone else asked a question in the similar vein. And the question was effectively, hey, that's illegal. They can't do that. So what is it, specifically that you're trying to address with this? And I'm agreeing with you. Yes, that's exactly correct. That a bunch of Board of Selectmen, for example, meeting at a coffee house or in someone's sunroom, and having a off-the-record discussion and vote that is neither in a open meeting nor in a closed meeting cannot authorize the expenditure of taxpayer funds to defend against a lawsuit. They can't do it. The law says they can't do it. But the question is, say they do it anyway. And the town attorney says, okay, I got the phone call from the head of the BOS. The head of the BOS says that they want me to defend the planning board's or the zoning board's decision to put in a oil refinery in the middle of a, park or whatever. That shouldn't happen. We absolutely agree. And yet, it's something that can happen. There's, we've got laws, but there's no, law of physics that stops these people from doing it, that phone call from being made, that check from being signed. So the question is, when such a sequence of events happens, what remedy do citizens have afterwards? And that's what this bill speaks to address.
Just follow up.
Follow up.
And my
Last one,
follow-up would be, they can't authorize it in the private, they can't authorize it in the off-site, non-public session. So they have to get into they'd have to get into a non-public session to do that, to get the authorization. They couldn't just make the phone call from their meeting at what.
I
whatever.
understand the question.
But,
and it's
and
an
I'm
ex-
not even sure it's criminal, because now the solution apparently from the bill is that it's a civil thing that anybody can, whether or not, and you might want to clarify this portion of it, can anybody in the state of New Hampshire who just thinks it's a bad idea get into civil court with this because it says anybody can do that? Or maybe am I misreading that?
that was excellent. I believe there's two questions there. The first question, the first question was, or the first was basically a statement, and the statement was, but current law does not allow a BOS to meet and, without going into either open or closed session, authorize expenditure of funds for the defense of a lawsuit. I 100% agree with you. Current law does not authorize that to happen. Current law also doesn't authorize, murder or burglary, and yet those things happen. So the question is, when an illegal action like that happens, what is the remedy? And this bill seeks to provide a remedy for a thing that should never happen because it's illegal, but a thing that does happen. The second question was, who does this bill authorize to push for enforcement? And your observation was that it says, I'm not sure what line number, but something, any person, that is intentional, and that is part of it. So that, if, Joe the plumber was an example earlier, if Joe the plumber has a backroom deal, he is, gets some spot zoning so they can park trucks in the middle of a residential area. The zoning board gives him, spot zoning approval, even though spot zoning has been illegal. The neighbor next door, goes through the political process in the town. The BOS says, we've heard your objections, but we don't care. The citizen then sues. The BOS meets in secret session and authorizes expenditure of taxpayer dollars to defend a clearly losing lawsuit. And then after it's all over, under this bill, there's the proposal of what can a citizen do to, enforce the fact that the BOS should not be having secret meetings and illegally authorizing expenditures. And so any person could speak to the one citizen who originally filed the lawsuit. It could speak to another citizen who is like-minded and lives on the other side of Joe the plumber. It could, et cetera.
Thank you.
Are there any further questions from the committee? All right. Seeing none, thank you very much.
Thank you for some excellent questions.
Is there anybody here? No? All right. We will close the public hearing on House Bill 292.
Okay, being 10:47, we're going to open the public hearing on HB 302 FN and recognize Representative Love to introduce his bill.
Thank you, Mr. Chair, Madam Vice Chair, and the rest of the committee for hearing my testimony here. I'm here to introduce House Bill 302, a bill that would make constitutional training more stringent and you know, a better training for our police officers. I thought about this idea a couple of years ago, a year and a half ago or so, while we were at the Bedford State House. We voted on a bill to eliminate qualified immunity for our law enforcement. And you know, coming from a law enforcement family, I knew that wasn't a good idea. I don't want our officers out there second guessing every move they make. But anyway, I went to a seminar, and you know, it was about qualified immunity, and it was mostly all people that wanted to get rid of it. You know, the ACLU lawyers and stuff, and one of their main objections was the lack of constitutional knowledge by our police officers. You know, these are the guys that are here to enforce the Constitution, and you know, they felt that you know, they didn't have enough training in it. So I put this bill together. I spoke to John Sippa about a year ago about it, and he and I just spoke, and you know, we both kind of agree that you know that you know, constitutional training for law enforcement is a good idea, and you know, the difference of opinion that we have, and I'm not I wouldn't object to knocking down the 8 hours that I have here down to 6 or whatever, you know, whatever be appropriate. But we just need better training, and you know, it's to fend off the attack on qualified immunity is the reason I put this together, and that would be about it.
Thank you for that. I'll take the first question. Have you conferred with Director Skipper and asked that they do have constitutional law training as part of their academy, correct?
Yes, they do, and you know, you know, the opinion of those at that seminar, and you know, Director Skipper doesn't seem to be too averse to you know, adding a little more, and you know, we've just got to do better. You know, I was just talking to him about an instance. My brother, we both drive limos, and at 2 o'clock in the morning, he was pulled over. A cop pulled up behind him with the bright lights on and all the rest, and blinding him. So he just pulled over to let him by. He didn't know he was a cop, and you know, he got read the riot act, and you know, have you been drinking? You're all over the road. Well, you know, when you've got bright lights shining in your eyes, you tend to do that, and you know, my brother had been sober for 25 years at the time, but anyway, you know, it was you know, it's something that shouldn't have happened, and you know, if the officer had more training and stuff, maybe it wouldn't have. You know, I've talked to other guys I drive with, and that they have the same problems in some of the small towns. You know, so you know, if we have some better constitutional training, you know, for the people that are there to enforce the Constitution, I think New Hampshire would be a better place.
Thank you. Representative Muse.
Thank you very much. The Constitution is a really big document, and 8 hours isn't a heck of a lot of time. Are there particular areas of focus you would like to see the training zero in on?
Thank you for the question. Absolutely. You know, it's written here, the Bill of Rights. Okay, I don't think police officers need to know commerce law and election law and stuff like, you know, let's focus on the Bill of Rights.
Representative Newell.
So, specifically, if you're talking about the Bill of Rights, I mean, that's a pretty short piece of it, right? And if there's already training, I'm just wondering what kind of feedback you got as far as, is it the training that's lacking, or is it kind of, you know, the testing, the demonstration of that knowledge?
Thanks for the question. It's a good question. Well, I guess it wouldn't be very fair to test somebody on something that they haven't been trained on. So, you know, the training is necessary. You know, you know, it'd be more thorough. Some might have enough to get through a test and, you know, and score maybe a 70%. But I'd like our law enforcement to be able to score, you know, 95 to 100. And if they have the training, they can.
Thank you. I think at this point, it would probably be best to hear from Director Skipper.
Yes.
Thank you very much for bringing this bill. Oh, I'm sorry. Absolutely. Just if it's, I think we pretty much know what he knows. So go ahead.
I was just trying to understand the connection to qualified immunity, and your bill. I misunderstood your connection between those. I'm really sorry.
There is a push to get rid of qualified immunity. Do you understand what qualified immunity is? Okay. There's a push. We did have a bill. I'm not sure if it was last year or the year before, to do it. It was a close vote, and you know, I think it'd be disastrous for law enforcement. It'd be disastrous for society in general. And
Representative Sitek.
I don't want to protract this, but you may be headed in the wrong direction. Here's why. I can't imagine a patrolman saying to his sergeant, "You've just asked me to do something unconstitutional because I've just read this. I had a training." That's not how line command works in the police department. I have some experience with that. Would you comment on that? How can you tell your lieutenant, "No, you're wrong"? That's what the courts are for. That's my concern.
if I was a police officer, thanks for the question. If I was a police officer and I was being asked to do something unconstitutional, I'd certainly have a record of it. And if it's a lieutenant, I'd ask a captain.
Thank you. I think the answer to that question is not part of this bill. This is the training part. As far as how the departments handle that, I think is an internal matter that this doesn't reach to. Thank you for your testimony. And at this point, I'll call Director Skipper.
Thank you, Mr. Chair. Good morning, honorable members of this committee. For the record, my name is John Skippa. I'm the Director of New Hampshire Police Standards and Training. We are the sole source for recruit training here for every single law enforcement agent here in the state of New Hampshire. We also serve as the primary source for incumbent or in-service police training throughout the state of New Hampshire as well. Thank you for your allowing me to come and just share some of my thoughts on this particular bill. And Mr. Chair, I would ask, if I pass something along to this committee, does it become a public record? It does, okay. And so in that case, I will not pass the document around only because it contains test information and a facilitator guide for the actual block of instruction. But I hold here our 12-hour class on constitutional law, which is delivered at every recruit training academy that we deliver in New Hampshire. This was compiled and built by one of my training specialists who is an attorney as well as a certified police officer. This lesson is not only lecture based but also scenario based. Yes.
If I could, I thought your intention was to give a handout. If you want to just pass that around to let folks look at it, it doesn't become part of the public record.
Excellent. Thank you.
Yeah.
I would ask every member, if you have an opportunity, to look at the table of contents because it clearly sets forth each module of the entire lesson plan. This lesson plan speaks directly to those constitutional aspects that a law enforcement officer is going to need to know. And to Representative Love's position, there are portions of these documents that are just not relevant to law enforcement. And so we concentrate our efforts on those areas that are specific to law enforcement activities. We speak not only to the federal Constitution and the state Constitution, certainly Bill of Rights, but we also talk about historical data as well, and some of the just human rights that came before any constitution did. We really want to build out a strong foundation with these recruits with regard to those aspects of constitutional law that they're going to be working with every single day that they go out on the street. I would like to share with you that I am extremely proud of this work product that's going around the table. And in fact, next month, I have been invited to participate in a national study for directors of law enforcement standards and training internationally, where I'm going to be attending a program on the development of best practice for teaching constitutional and procedural justice that will lay out really kind of a framework on a national level with regard to teaching the Constitution to new police recruits. And I've already forwarded this document to the committee as we prepare to have these discussions. And already I've received a tremendous amount of really accolades to pass along to the person that developed this. This is, in my opinion, serves as an example nationwide on how we should be teaching constitutional law to recruit officers. It's also important to understand that, particularly with teaching adults, lecture is not the best way to get the point across. You really want to create opportunities where you give adults fact patterns and let them work through it themselves. Have that open discussion. Try to come to the appropriate decision in a safe environment, right? Through scenario training and group projects. Those laminated cards that are going to follow that lesson plan and facilitator's guide are actual scenarios that we use at the academy to teach those recruits as they go through this program. I would welcome the opportunity to work with Representative Love and really anybody in this state, quite frankly. If there is a concern that we are not providing the best instruction that we can provide to our police officers, particularly with regard to constitutional law, I stand ready to work with anyone. And I was lucky enough to have a conversation with Representative Love before testimony began. I certainly would look forward to sitting down and working with him to see maybe the shortcomings that he might have in his mind, whether we are addressing those shortcomings that he believes exists. And if they do exist, then let us work to make a phenomenal lesson plan even better, quite frankly. My other concern is it's important to teach the content. Hours is just checking a box. If you did 2 hours of instruction, it might be 45 minutes of content. It could be 4 hours of content you're trying to shove in a 2-hour block. It's important for me and for my staff to make sure that we are representing appropriately as we teach these topics, not only constitutional law, but any law or any block of instruction, that we are valuing the time of the student and we are valuing the time of the home agency that is paying that student to be in that seat studying to become a police officer in the state of New Hampshire. And so I was very concerned when there was actual hours attached to this bill. And again, I would certainly look forward to working with Representative Love and any other person in the state of New Hampshire who thinks that we need to revisit what we're doing here. And I stand ready to respond to any questions.
Thank you, Director. Did Representative Love have an opportunity to look at these yet?
But not yet. We literally just saw each other. We've talked on the phone a couple of times, but first time we've met, so not a chance yet.
Thank you. How do you the course material is good. How do you ensure that they're understanding the testing process, that they've absorbed this and they know it?
Thank you very much, and it's an excellent question. Written tests are just that; they're written tests, and genuinely, you're measuring the student's recall. That's all you're doing is you're measuring their ability to remember things. It's more important for us to make sure that they can, as the representative spoke to, actually perform, comprehend, understand, negotiate to the correct answer. And that's why it's vitally important for those scenario and group trainings to take place. We measure on a written test, which is included in the back portion of that facilitator's guide. But we also measure through a grading rubric that's been designed by our curriculum coordinator to make sure that when they do these scenarios and they do these group projects, that they're able to take a fact pattern that may be murky, because let's all agree that being a cop it's a murky job. There's not a lot of bright lines, and you really have to be a problem solver. So put these young people into groups, let them take those murky facts, let them work through it, have discussions, come to the answer that they need to come to, and then be able to defend. Why did you come to this answer? Why do you think this is the best approach? And it's always fun to let them defend their position in front of their peers. That's where the best discussions happen because they're pretty tough on each other too. So it's a good learning experience.
Also, I would ask, constitutional law, as you know, can change by the minute sometimes. How do you address it once they've left your academy? How do you make sure that they're keeping up with it?
Thank you for that question as well. One of the things, and candidly, kind of fell off of our radar right around when COVID hit, was that we provided an annual law update. It was really just a flyer. It was no more than a flyer. It is my intention to create an annual in-service program that every officer can complete online to include testing with legal updates, New Hampshire legal updates. That is something that our state has never mandated, but it's something that I would like to institute in 2023. We now have the staff to be able to put that together. And so to address those types of concerns, as well as just changes in motor vehicle law and training and things of that nature, I think it's very important to send out the consistent, clear message and attach a testing component to it as well. And we can do that through our online learning bureau.
Is there currently an in-service requirement that they have every year?
There is not.
Okay.
We have mandatory in-service training hours that are required, but we do leave a fair amount of that to the chief executive officer of each agency to determine what would be the best way to spend those training dollars for that particular community. Candidly, I think it is important that we create, in conjunction with the Attorney General's office, and we have a great working relationship with the AG's office, to create that annual legal update, and we deliver it in a very defined way.
And my last question, your agency has anything to do with officer discipline or issues that occur later with their licensure? There was a scenario brought up about, if someone was ordered to do something unconstitutional. Can you just speak to that shortly, if you could?
Absolutely, Chair. And thank you for that question. As of January 1st of this year, New Hampshire Police Standards and Training now has a very clearly organized conduct review committee that has been established to address any allegation of defined police misconduct under RSA 106L. being given an unconstitutional order could very well fall under that committee's review. Certainly, an unconstitutional act by a police officer is going to, in the first instance, negate any law enforcement action that they took, and certainly would open them to civil penalty for conducting that kind of unconstitutional act. And it could very well expose them to criminal liability as well.
Representative Newman.
Yeah, I just have a quick question. You mentioned 12 hours of training when you first began your testimony. Was that 12 hours in constitutional training, or was that, I haven't seen the documents yet, or is that a bigger piece of stuff?
So thank you for that
'Cause
question.
I looked at the first part, which looks like it went article by article, where, you know, the Fifth Amendment and all the amendments are important about searches and whatnot.
Thank you for that question. The 12-hour block of instruction is to deliver the lecture and to apply the scenario training for constitutional law. It's also important to understand, while we have this block of instruction on constitutional law that builds the foundation, I can tell you that right now, I just left. I was monitoring a class that was being delivered by a member of the Attorney General's office, and that's an 8-hour block on search and seizure. So we introduce the notion of protections under the Fourth Amendment and Part 1, Article 19 of our state constitution relative to searches, seizures, and the arrest of people. But these students get that reinforced every time we have a separate class. We have a class on laws of arrest. That's another 8 hours that builds off of the 12-hour block of constitutional law. We have an 8-hour class on search and seizure. Again, that revisits all of the foundation class of the constitutional law class. When we talk about defensive tactics and they're down there, rolling around with each other and pinning each other to the ground, there is a discussion both on the constitutional application of force and the ethical application of force as well. We build in blocks of instruction relative to ethics in every one of our classes as well. Again, it's they're going to eat this elephant, but they do it in very small bites throughout the 16-week academy. And I hope that answers your question, sir.
And a follow-up to that, and it was kind of the genesis of it might have been the question about what a police officer does in when they think they're being asked to do something that's unconstitutional. So it's a command, a person that is in authority, and then being told to do something that you're not quite sure of. And it could be like the famous case where someone was killed and there were 3 officers working, and you have his boss, and just came out of instruction and all of that kind of stuff. Is there training in there in your organization to address things that you might have been divulged to you by that kind of situation?
Absolutely. Thank you for the question. Yes. Again, there's statutory requirements for police officers to report misconduct that is alleged to have occurred by another police officer. That is RSA 105-19. And that requires officers to report specific allegations of misconduct that they actually witness. I'll tell you a funny story. When I very first started as a police officer, I graduated from the academy. I went back to my home agency and was talking about a situation with over a coffee. There was a bunch of us sitting around, and my boss came in, and I respected the guy very much. And he said, "Well, you could have just arrested him and held him for 4 hours." And in fact, many, many, many years ago, I'm not going to tell you how many years ago because it was a long time ago, but you actually could do that until a New Hampshire Supreme Court case dictated that you cannot arrest somebody and hold them for 4 hours without having probable cause to make that arrest. And I share that with this committee because that's an excellent example of how a police officer who's now in a position of authority they believe that they are acting with best knowledge, and in fact, there's been a change in law that they're not aware of. And candidly, to Representative Love's response, in the first instance, that younger officer should ask for review by a higher up, and if he needs to go by or she needs to go by that supervisor to the captain, as Representative Love said, that's the very first step to fix that immediately. And certainly, you know, if they can't get it fixed, they can reach out to us and we can address it as well.
Thank you.
Representative Newell?
So I'm curious, I know well, I guess it is kind of a two-parter question, but it just goes really quick to um, I'm guilty of all of these all the time. Okay. First of all, how long has this particular module been in use?
I believe it is on the cover,
Oh,
and I'm only saying that because I can't remember, but this came out of recommendations from the LEAC Commission, which seems like yesterday, but I believe it was a couple of years ago when that summary report was issued. And one of the steps that I took was to corral my folks and say, show me what we have. We need to do better. Let's build this out better. And that is a result of that directive. So probably the last couple of years.
the second part of my question is there, I know that, you know, we already spoke to kind of what I would call continuing education just because of the, you know, professions I've been in, and that being in the process of being made, and that would be for updates and things like that. My question is for people who have been in the police force for much longer than that module has been in use. Do they then go back? I know that this is in the training academy, so this would be something, you know, first training. Is there, you know, has there traditionally been the opportunity for officers who maybe didn't go through this, you know, comprehensive and thorough module to go back and get that same education?
Thank you for that question. It's an excellent question. Candidly, there's no mechanism to provide that opportunity to come back. That doesn't mean that we can't just offer this 12-hour block of instruction as an in-service program and allow any police officer in the state of New Hampshire, corrections officer in the state of New Hampshire, state corrections officer, to attend that particular in-service program. I will tell you that anecdotally, we are crushed for space in our building, and we have a very small teaching staff, and so that also becomes part of the overall discussion is making sure that we're allocating resources appropriately to get the biggest bang for our buck, and that's why we see the development of online training programs to be the best way to address pushing that, as you spoke to, that, you know, kind of that you've been on for 10, 15, 20 years, you know, take maybe not 12 hours online. That would be a long time. But maybe we chop it up into smaller bites of an hour or two, because then that officer can do it on duty. They can come in and have their meal, sit in front of the computer and bang that out quick. And it also helps them maintain kind of their in-service requirements. They would get credit for you know, completing that. So you've helped me maybe look at a different way of building out the in-service. Thank you.
Actually, yeah, Representative Muse, you'll be last.
Thank you very much. I know one issue that's come up across the country, and I'm wondering if it has come up here at all in New Hampshire, is the issue of some officers believing that they have supreme legal authority and the power and duty to disregard laws that they regard as unconstitutional. How are you instructing officers in the academy when it comes to that? I'm sure that many of the officers are aware of that situation. And how do you think it plays into this conversation?
Thank you for the question. I would ask for clarification. I'm not, and I apologize. Some of it I didn't hear. Can you give me a specific example?
Sure. I think that across the country, there have been folks that have called themselves sovereign sheriffs. And when it comes to enforcing things like firearms laws and things of that nature, they've sometimes taken it upon themselves to interpret the Constitution that all those laws are unconstitutional, whether they're federal or state, and they refuse to enforce them. I'm just curious what the policy is on that in New Hampshire.
Thank you for that question, and thank you for the clarification as well. Candidly speaking, New Hampshire the common sense that is found as part of the bedrock of this state not only permeates throughout our state, but through our New Hampshire law enforcement community. You see those types of situations generally with constitutional officers, those officers that are elected by the people. Here in New Hampshire, I have never heard, I know all of the sheriffs. I meet with them monthly at their association meetings. That does not exist within the elected sheriffs here in New Hampshire. I've never heard of a sheriff speak that way. They are presently, every sheriff is a certified police officer in the state of New Hampshire. Constitutionally, it's not necessitated, but they all feel it's important to be certified as a police officer as well. And I have never heard of that type of discussion or position by any of our elected law enforcement officials here in New Hampshire.
Thank you, Mr. Chair, and thank you for taking my question. I was just wondering, so in the bill, it talks about 8 hours of training as well on the New Hampshire Constitution. Is the New Hampshire Constitution addressed in this curriculum, or is that like a separate module that officers take?
Thank you for that question. That is the New Hampshire Constitution that is specifically relevant to law enforcement activities is included in that block of instruction. And candidly, I have a copy of the New Hampshire Constitution that sits on my desk. And candidly, there's probably 2 or 3 pages of that very thick book that apply to law enforcement activities.
Actually, can you describe just a little bit? I think it would be helpful, kind of in the context of this decision now that, or discussion now that I've gone ahead and raised it. But what kind of instruction is currently in the 12-hour program around the Second Amendment? What are we telling officers to do, to not to do, to be careful of? How does that work?
May I refer?
But if you give a short answer, that'd be okay. That's not really relevant to that's really diving into the weeds of this bill, but go ahead.
I think that we talk about the fact that the Second Amendment exists. I would really want to look at that to speak accurately to it. We create scenario training, not so much at the constitutional law class, but at the end of the academy, we have what we call a applied patrol procedures section, where we create a scenario where there's a law-abiding citizen that's carrying a firearm and is protesting, and we ask the recruits to negotiate that and do it in a safe way, but do it in a way that protects everybody's rights. I don't know if that's helpful to answering your question.
It is helpful. Thank you very much.
And sir, if you want to speak offline with some other questions, I'd be happy to talk with you.
Thank you, Director. I think that to answer that question might take 4 hours because there's a lot involved in that. If just for the edification of the committee and perhaps to answer Representative Muse, scenario-wise, you have a citizen walking out in front of the State House with an AR-15. What's this? What would the officer be trained to do in that situation?
Yeah, so that happens quite often here in New Hampshire. I can tell you that people who police in New Hampshire recognize that that citizen has a right to have that firearm. It may be inappropriate in the officer's mind, personally, that somebody's bringing an AR-15 to Walmart, but they are still entitled to do that. The officer is going to introduce themselves. They're going to explain why that they're contacting the person who has the firearm. We've received a number of complaints. There's a lot of people that are concerned. I'm here to just make sure that everything is all right. They're generally met with, I have a right to have this. I have a right to have this. We recognize that right. Yes, you do have a right to have that. Just understand that there's other people that were concerned, and they called us. In the end, just that give and take on the side of the road, just that discussion is enough to provide an opportunity for the officer to evaluate whether there is a threat that exists or whether it's just a law-abiding citizen who chooses to bring their AR-15 to Walmart. And again, I spoke about it earlier. Being a cop, oftentimes it's murky. You're in a gray area, and you're trying to do the very best you can with limited information with people who may not be completely cooperative with you. So the officer is trained to do the very best they can while protecting people's rights, but also keeping people safe and making sure that crimes are not going to be committed. It's quite a tightrope. We have a lot of vacancies if anybody's interested.
I believe Representative Love is interested in taking your common law class. Thank you for your time this morning, Director Skipper, and thank you again, Representative Love, for bringing us this bill. Is anyone else? You're all set.
Thank
is anyone
you.
else wishing to testify on this bill who wasn't testified? There being none, I'm going to close the public hearing on what was this? HB 302, and the committee will be in recess until 5 minutes. It being 11:30, it's time to open the public hearing on HB 421. And I will recognize the prime sponsor, Representative Reed, to introduce her bill.
Thank you, Mr. Chair, and thank you once again, honorable members of the Criminal Justice Committee. I can promise you it was not my intent to come before you 3 days in a row this year, but I did end up supporting bills that I was co-sponsor on and wanted to show support for those. So for the record, my name is Ellen Reed. I represent Newmarket and Newfields, and the bill before you would codify what is already, certainly in my interpretation and in most people's interpretation, the constitutional requirement that prisons and jails provide basic menstruation hygiene products for women or inmates who menstruate. So I want to just first say that I will use the term woman. I am using that in the biological sense. I am not getting into any other political issues. I want to strictly talk about the biological need for products to address menstruation, which is a real thing. I will say that not all women obviously menstruate, but 80% of women who are incarcerated are of menstruation age. And so therefore, when we say women, we are talking about most of the people that we're talking about are likely to need these products. So as I said, I think that we are all very clear, both on the federal and the state level constitution, that when we incarcerate an individual, it becomes the responsibility of the government to provide for their basic health and hygiene. Obviously, menstruation falls under that. And when women do not have access to period products, it becomes an actual health issue. Women, and I'll speak broadly about women in what's called period poverty, who don't have access to products in general, forced to use toilet paper, napkins, paper towels, socks. In incarceration, those products become rare as well. And so they can be forced to use really anything they can find that is absorbent. When you're not incarcerated and you are in this period poverty, it inhibits people from being able to participate in social activities. There's a sense of shame, obviously, that comes with that, especially if that evidence is visible. It is the same in incarceration, where women who may be liable to have blood on their clothing would not want to engage in the small amount of time they get to engage in social activities or in enrichment activities that the facilities do provide. So because specifically in my bill, I say as needed, as adequate for the person who's incarcerated. You might notice that there's no fiscal note on this. As I said, it's already a constitutional requirement. I believe the reason, after talking with several people, the reason there is no fiscal note on this is because, first of all, for the most part, jails and prisons are already providing these products, but they're not, how should I put it, maybe putting the kind of priority on the needs that is necessary, because we do have repeated anecdotes of women who are not getting the products in a timely manner or not getting products that are appropriate or adequate for their needs. And I know that you'll hear a little bit of that information today and or getting it as written testimony. So I won't go into too much detail except to say that as I said, there's sometimes barriers to getting it that provide inadequate or inappropriate amounts of time waiting for products. One person I know, at least one woman inmate in the state, developed an infection from not being provided the correct or adequate products. In addition, the women who are incarcerated are overwhelmingly in poverty or lower income people. And it turns out also lower income women are far, far more likely to have gynecological conditions that make them more likely to need menstruation products, conditions like PCOS, where women can have extremely heavy and extremely long periods. So I happen to know from very personal examples that women with PCOS can bleed for over a year, and in fact can bleed so heavily that most products are inadequate to the flow. Finally, I will say, I'm sorry I missed this point because I was just, I got sidetracked, but the constitutional thing in the fiscal note, the reason that I don't think there's a fiscal note is because since it's already a constitutional mandate that we take care of the basic health and hygiene of people who are incarcerated, that, and in fact we do sometimes, but it's not being followed adequately, that there's no extra actual money being spent. And in addition, since it's already a constitutional requirement, does not become an unfunded mandate because it's already a mandate. If the bill were to specify a certain amount, then that might change. But the last point that I'll bring up, because I do have a couple of experts who made their way through the snow here today, I think we originally were supposed to have 3 or 4 women who were going to give you their personal experience in incarceration in this state. Unfortunately, the snowstorm made it impossible for them to come up, but we do have a couple experts that managed to make it today, and I want to thank them. So I'll end by saying this language very similar to this was already passed by 15 states, including Alabama, Arizona, Illinois, Mississippi, North Carolina, Nebraska, Tennessee, and Virginia. So it is a widespread problem that I think it doesn't hurt, even though I'm saying that it's already a constitutional mandate that we provide for basic health and hygiene. This is a kind of belt and suspenders approach, because right now, if a person who's incarcerated experiences a problem, their only real avenue of addressing it would be to start a court case and challenge it constitutionally, which those resources for an inmate is almost impossible to acquire. Having a law will kind of encourage the correctional facilities to obey what we believe is already a constitutional mandate, where they might not be taking this particular thing very seriously at the moment, and B, would provide more legal action available to people who experience a violation of this. So with that, I'm open for questions.
Thank you, Representative. When I read that this bill was coming, frankly, I was shocked that it would even be necessary. And if that is the case, it certainly needs to be remedied, as that's barbaric. Can you speak to some of the possible health implications of not being able to take care of this? I mean, you can get UTIs. Do you know anything about that? Could you speak to that?
So a little bit. I'm not a medical doctor, but we do know of at least one female inmate who's developed an infection from being given products that were not adequate for her. There are a wide variety of products that might be necessary. For example, I believe Carroll County in particular only offers pads. And I believe, and again, this is anecdotal, so I'm piecing together information from different stories, but only one size or type of pad. This can be problematic, and the largest, basically, in order to kind of cover their bases. But that isn't adequate to people with smaller bodies that can bunch and not be comfortable. And so I know that some of the inmates there were requesting things like tampons. Tampons tend to fit a wider range of women because women's bodies, external bodies, tend to vary more. So in terms of, yes, UTIs, I have a female relative who developed a UTI from improper use, and other infections as well. I believe things like yeast infections, but again, I'm not a medical doctor.
And I'm sure if I don't ask, someone else will ask. If someone's going to talk about this, one of the witnesses, you don't need to, but is there a specific institution or place that this has happened that brought this to your attention? And if someone else is going to talk about it personally, that's fine.
So I think you will get more information from the experts. I believe, and I might be getting my stories confused, that the Carroll County was the location of the person who got the infection. I believe the state tends to be a little bit better in their practices, but even as we were researching, it was hard to get information from these facilities as to what their actual policies were. How did women who were incarcerated acquire materials when they needed them? I will also add the health piece of inadequate if you provided too strong of a product. That could also run the risk of toxic shock syndrome.
Representative Sitek.
Question of the chair is, are there any cards from the Department of Corrections on this? Yes. Okay, all right.
There being no questions, thank you for your testimony.
Thank you.
Representative
No.
Muse.
Just looking over your bill very quickly, one of the things you alluded to is that women may need different types of products. I just wanted to point out in your bill, it doesn't really address that. So the Carroll County situation you raised, where only one type of product is available under your bill, the way that it's currently written, that may be an acceptable practice. I just wanted to point that out.
So by one interpretation, I can see your interpretation. By one interpretation, since it says any product designed to address menstruation, then you could interpret it as perhaps even overly broad. So I'm happy to address whether within the committee, on the floor, or in the Senate, or in a committee of conference, I'm happy to address any language changes that are necessary.
Thank you very much. I think we want to solve the problem.
Thank you. At this time, the chair will recognize Daniel Popovich. Can you turn the mic on?
I should know that, but I'm new. Thank you. I will try to keep my remarks as brief as possible because there are a lot of people here. And obviously, I will not repeat any of the points already made by the primary sponsor. I just want to address a few things. First, I heard the chairman say that he was surprised the legislation is needed. Frankly, that was my first reaction when I heard about a bill. Why in God's name do we need it? But the fact is that we do. So the question is, how can we craft this bill to address the issue in the best way? When inmates are in a situation where their constitutional rights are violated, it's extremely difficult for them to get redress to it. Very few people have the ability to mount from jail a lawsuit and try to get their rights addressed. So this bill will clarify what the obligations are and both reduce the impact on the people whose rights may not be respected, and it will also decrease the risk of large constitutional lawsuits that will cost a lot of money for everybody involved, and inmates tend to use public defense, so all costs will be borne by the state. So in my opinion, this will definitely help in both improve the practices and decrease legal risks for the state, which are all positive outcomes. The questions about the specificity of the amount and type of products is a very valid question, but if we try to be overly specific, it could end up with a fiscal note. And this is really not a year where we want to, take the risk that the finance committee, which I'm brand new on, so I cannot really speak for them, but just as myself, it would be best if bills would have a minimal fiscal impact this year whenever that can be done while still addressing the issue. And my concern with specifying an amount, for example, would be that you get into a Goldilocks situation where whatever amount we specify will be too much for some people who don't need it and too little for other people who need more. I think that the use of the word adequate amounts as necessary is really a really good way of defining what's needed. Obviously, the prison wardens and the personnel have the ability to deny products that may be dangerous. Some of the potential things may not be suited for a jail because they can be modified into weapons or whatnot. So just saying adequate amounts of necessary, in my personal opinion, allows the prisons to maintain their safe environment while addressing the needs and not, being too specifics about the amount, which would create issues either way. I just wanted to keep it to 2 minutes. I think I'm reasonably close. I appreciate your time, and this is my testimony unless you have questions. Thank you.
Thank you for your sharing testimony
Thank
with
you.
us today. It's time the chair will recognize Riley Rodell. Please feel free to correct me if I did something horrible to your name.
Hello, my name is Riley Rodell, and I am a high school senior from Hollis, New Hampshire. I'm here today to testify on the behalf of House Bill 421. I am also a volunteer for the organization The Period Movement, which is an international organization that seeks to eradicate period poverty in our lifetimes, and I am currently the period community organizer for the state of New Hampshire. When menstruators do not have adequate access to period products, they are forced to use products longer than intended or attempt to make products using materials that are available to them. In addition to being unsanitary, this poses several physical health risks, including toxic shock syndrome, infections, sepsis, all of which can ultimately lead to infertility. Lack of access to period products have been linked to mental health issues as well. Period poverty is associated with increased risks of anxiety and depression. Period poverty is limited or inadequate access to menstrual products that can affect people who menstruate in any walk of life. Ensuring that it does not affect more vulnerable segments of our population who cannot necessarily advocate for themselves is part of our civic duty. Kimberly Haven, a reproductive justice advocate, reports that during her time in jail, she witnessed women declining visits with their families and with their attorneys because they did not have adequate access to menstrual products while on their periods. Ultimately, this conversation comes down to one of human dignity. Each one of us deserves to be able to manage bodily functions adequately, including those who are in prison. For nearly half of the population, this includes proper access to menstrual products. No one should be forced to risk toxic shock syndrome, sepsis, infection, or infertility to manage a natural body function. Periods are not a luxury, and the products that are necessary to manage them are not luxury items. They should be provided along with all other necessary hygiene items, such as toilet paper, to those in state or county custody that require them. I would like to thank the sponsor of this bill, and I'd also like to note that New Hampshire has been at the forefront of menstrual equity legislation for a few years now. As some of you may know, in 2019, New Hampshire was the third state to require period products in public middle and high schools by law. I encourage all of you to support this essential piece of legislation and continue to serve and protect the dignity of all those who menstruate. Thank you all for your time, and I'll take any questions if there are any.
Thank you very much for your testimony. I know, would you be able to submit that for the committee for our record?
Yes.
You can email it if that's your only copy, or you can turn that in if you want.
Okay, thank you.
Does anyone have any questions? Seeing none, we appreciate you coming and sharing with us today. Thank you very much. The chair recognizes Christy Kim.
Good morning. I am here today representing the National Council for Incarcerated and Formerly Incarcerated Women and speaking on behalf of the directly impacted women who are not able to be here today because of the snow. In 2017, the women from the National Council wrote the contents of the Dignity for Incarcerated Women Act. In 2019, U.S. senators and representatives reintroduced the act, which would highlight the need for improved conditions for incarcerated women. Representative Jayapal pointed out that the act, among other things, will ensure that mothers never have to choose between calling their children or buying a tampon. Accessing sufficient feminine hygiene products primarily in New Hampshire jails, but also in the women's prison, is a concern as we sit here today. Angelica, a currently incarcerated female, noted that during her stay at Belknap County Jail, there were times when she did not have enough pads and tampons. Furthermore, she was issued used underwear which contained blood stains from other women. Melissa, a formerly incarcerated woman, recalls getting only, and I quote, giant-sized pads that felt like diapers at Carroll County Jail. She was never provided with tampons. The underwear that she was issued were stained with urine and blood. During her time at the women's prison, while working in the property department, she was part of discussions to recycle underwear and work to sort through used underwear to find, quote, the good ones. Tanya, also a formerly incarcerated woman, echoed the reality at Carroll County Jail, stating that she never got tampons and was subjected to wearing stained underwear and sleeping on sheets that were also stained with blood. During her stay at the women's prison, she would occasionally run out of tampons and ask other women for extras, of which lending and borrowing is a disciplinary offense. Natalie is a formerly incarcerated woman as well. She recalls her previous experiences in Cheshire County Jail as this, quote, "You only get certain amounts of tampons depending on which officer was working the unit. As a state county resident, you would get used underwear, used bras, and used socks. The sheets were also old with stains. The federal residents were taken care of because liaisons visited once per month to ensure that they were getting their needs met. At Grafton County Jail, they also issued underwear that were stained. When I asked for a new pair of underwear, I was told, 'You're lucky you're getting some because if it were up to me, you would get nothing.' So I chose not to wear any. My sheets were stained with blood and I was only ever given pads, not tampons. Merrimack County Jail limited the amount of tampons you could have, and you had to buy them if you needed more. At the prison, they always gave me stained sheets and underwear, and extra tampons were hard to get because not every officer liked you," end quote. With only 3 pairs of issued underwear per woman and the inconsistent supply of feminine hygiene products, many of which were oftentimes very expired, as much as 3 or 4 years of the pads that were handed out, women are forced to wash their underwear in the push-button sink because the twice per week laundry times are not sufficient. It's also important to note that washing your clothes in the sink and not wearing underwear are D offenses. We are talking about a basic need that should be honored in a dignified manner, and I encourage you to support this reasonable bill. Thank you.
Thank you for your testimony. Being no questions, thank you. Oh, wait, sorry, got one. Representative Salig.
I just want to clarify. So this bill talks about just feminine hygiene products on a broad stroke.
Yes.
So would that prevent a prison from saying, we'll give you extra underpants that are perhaps have extra liners, such as the ones, like they make for teenagers now that are designed to be period pants?
Mm-hmm.
I can't speak to exactly what you're asking. I think that I can only tell you that there are certain rules within the prisons. The women are only given 3 pairs of underwear. They must prove and show the tatteredness of underwear to get new ones. In some cases, if you have money on your quote books, they will not issue extra underwear. I know that this bill is talking about feminine hygiene products. We are going on the record just talking about the used underwear, just to get it on the record. I know that this bill doesn't specifically address that. I can't really speak to the language. I hope that answers somewhat of your question.
Thank you.
Yeah.
Representative Muse.
Thank you for taking my question. During her introduction, Representative Reed said there is a requirement in New Hampshire that these products be provided, but it sounds like the current practice may be to provide access to them. So, for example, your example of the woman who didn't have enough, who had to buy more, the fact that more are available to be bought, do you see that? I mean, do you see that as part of the problem we need to solve?
I do see that part of a problem. One, because not every woman has money to be able to purchase more. And you can only purchase more through a union supply book, which requires, it can take up to 6 months for a delivery to come in. It can be as little as a month, so you never really know. And you also have to go through a pretty formal process of getting money on a slip of paper to the right people. And so you might not get your order for quite some time. It's not something that you can just purchase on a commissary, which would come in the following week. And I do think that women shouldn't have to pick between how they're going to spend maybe $1 a day that they're earning at money on their phones to call home to their family versus getting a box of tampons that they need.
Thank you.
Thank you.
Representative Newell.
Thank you for taking my question. Unfortunately, I'm very familiar with this, although not in New Hampshire, and I'm horrified to hear that the way that description was given about Cheshire County, my own. What I was wondering is, we have a couple of different kind of pieces of language here that entail different things, right? similar to what Representative Muse said. You know, we're talking about adequacy, and then we're talking about limits. And so what I'm wondering is, if it's not based on that person's individual health needs, what is it based on? What is the number based on?
That's a great question. Excuse me. I can say that at the women's prison right now, they get a choice of like 15 regular tampons and 15 super tampons, or you can choose 30 pads, but you can't like have unlimited access. I don't know who came up with that number. It's a great question, right? Everybody's cycle is a bit different, and certainly changes if you have other conditions such as PCOS.
Representative Murphy.
Thank you, Mr. Chairman. I think this is a great bill. It's unfortunate that it's necessary. And just to address one of the issues that was raised before about the type of product that may be necessary for one woman, that would the only suggestion I would have is adding the word in adequate amounts and types as necessary. That would sort of cover without getting too specific. And because I'm concerned that just leaving it like this might lead to an inmate having to say, well, it says this, and they say, well, it doesn't tell us that you have to have tampons as opposed to. So if it's just a more general term, I'm just a suggestion.
I appreciate that suggestion. Thank you.
Representative Peru.
After hearing some of the testimony, I almost think that we need to expand on this bill.
Yeah.
Because I'm frankly appalled, right? That you get 3 pairs of underwear and you can't wash them for every other week or whatever that was.
Twice per week is the
Twice
laundry.
per
yeah.
week. So still not going to have enough.
Right.
So to me that, and then you get gigged if you wash them in the sink.
Yeah.
Yeah, that's
Yeah.
kind of crazy to me, but
Yeah.
that's just me. So I'm wondering if we need to include that in this bill, that you get adequate underwear and clean sheets. I mean, you would think we wouldn't have to, but apparently we do.
Right. I absolutely agree with you. I'm not the one writing the bill, but I certainly,
Yep.
yeah,
I know.
I appreciate that though. Thank you for that comment.
That's just me.
Representative Sue Newman.
Yes, thank you for taking this question. You mentioned that products could be or would be available for an inmate to purchase. And you gave a couple examples of that. Do you know if the purchase price is like reasonable, what we would?
Well, I do know it is not reasonable.
Yeah.
Union supply is often overpriced. I don't have the exact prices in my head, but I could imagine it would be as much as like $10 a box for, 15 tampons.
Thank you.
Representative Rhodes.
Thank you, Mr. Chairman. Thank you for taking my question. Is this something that a visitor is allowed to bring?
No, no one is allowed to bring anything into the prisons or jails.
Okay.
Yeah.
Thank you.
Thank you.
Thank you for your testimony.
Okay. Thank you so much.
The chair recognizes Representative Jess Edwards.
Thank you, Mr. Chair. I apologize for my uniform today. I testified on a veterans bill as a veteran and didn't do a quick change. So I'm here representing Rockingham District 31, an outstanding district, if I might say so. And I am going to testify to something completely different. I'm from the Finance Committee. I've been following the issue on menstrual products for a while because this issue has been raised with the school districts. And I have a bill in because of following that. And so particularly for the newer members of the committee, typically when we look at a bill, we look at it from a policy perspective, and then depending on assuming acceptance of a policy, then we look at it if there's a funding issue. This bill does not have a fiscal note, and that concerns me because I will just state, for the record, this is a no-brainer from policy. I'd be stunned if this isn't in practice, and I would want to terminate any leadership in the prison system that isn't already doing this and complying with it well. The policy is just an obvious one. So that gets us to the money issue. Article 28 alpha says that we shall not, as a legislature, issue unfunded mandates. And so if you look at the words here that we shall direct the counties to provide this service, because of our Article 28A requirement, I think the state has to fund it. And so this is not there's no fiscal note attached to this. I tried to get Mr. Ciani to give me an opinion on whether or not my concerns about this were valid. So that I would just leave to the committee, that I still think that there's an open issue here that, assuming this is good policy, are we walking into the obligation of a 28A to where the state needs to fund that obligation or that mandate? And I'm not enough of a constitutional lawyer to answer that, but I do think the answer is probably yes. If we tell the counties they must do it, the state must pay for it. And if we let this get out of the House and sent to the Senate without paying for a new policy that's a mandate, then we are failing to do our job. So that's my testimony. Thank you.
Thank you, Representative. Speaking as the chair, if this bill is amended in such a way, or it turns out in such a way that it does mandate, it will be sent to fiscal, and it will be run through the procedure to ensure that it's paid for. So your concerns are well met, and we will ensure that that is followed.
Thank you, Mr. Chair.
Representative Salick first.
Thank you for taking my question. Thank you, Mr. Chair. So is it your premise that tampons and pads are not a medically necessary product for people who menstruate?
I don't think I came anywhere near saying that. I think I actually am on the record saying exactly the opposite. This is a no-brainer of a policy, and if this isn't being followed, people should be getting fired.
Just to be clear, if you're going to ask questions of the witness, he did testify that he believes the policy is correct. He's concerned with the fact that if it's something new that we're mandating be done and paid for, that we just make sure it's paid for. That was all his testimony was. So
Right.
do you have a follow-up based on that?
And if I may, Mr. Chair, I've commanded women in the field in the hostile fire zone, and as a commander of those women, I have ensured that even in a hostile fire zone, that they had the materials that they needed to remain healthy. Disease non-battle injury is the largest way in which we lose soldiers in combat, and so protecting the force, protecting the female force is just something I've been doing pretty much all my career.
Okay, may I ask a quick follow-up?
You may.
I just want to understand, are you saying that you don't believe these are we not funding this now then? If we're theoretically providing this now, who's paying for it if it's not already included?
Okay, so this is a technical constitutional question, and one, as a representative, we should all be familiar with the New Hampshire Constitution and our obligations to adhere to it. Article 28 alpha is very clear that the state shall not issue a mandate without paying for the mandate. And so I think this is probably a good policy. I'm just warning the committee, and the chair is already aware of this apparently, that if this mandate to the counties goes through, this is going to need a fiscal note, and it will require the state to pay for the mandate. So I will again restate, I completely support this as a policy. I just worry about the money implication. and not because we shouldn't pay it, but because we're obligated to pay it, and oftentimes we fail to do our duty under the Constitution.
Representative, if you could, what is your current leadership position here in the State House?
Well, I'm in my second term as the chairman of Division III Finance, which is responsible for funding the Department of Health and Human Services. I think I was made the chair of that committee because I have an entire adult career in the healthcare field and in working in all aspects of it pretty much, other than direct care provision, because I'm not a provider.
And your testimony today is in that role to advise the committee of what may potentially be a financial problem. That's all. Is that correct?
Well, yes, sir. I would just say it's slightly different. First, it's a constitutional obligation. I don't want to lose the sight that we're responding to our constitutional duties, and that drives it into a financial issue.
Representative Bolden.
Thank you, Mr. Chairman. Thank you for taking my question. I think you're a little late, and I'm concerned that maybe some of what you're speaking to was addressed by the prior speaker. So I was hoping that I could just tell you what the committee's already heard, so that maybe you could dovetail that into your commentary on 28A and give us your additional thoughts. What we were told earlier is that the Constitution requires that prisoners at the state and county level receive adequate health care, and county facilities are already providing menstrual products largely, but not consistently, and that basically the goal with the wording of the legislation is to ensure that it is always provided and sort of cement its place among the definition of proper health care or adequate care in general. And so in that regard, it's not a 28A issue, I believe my understanding of the earlier testimony. And additionally,
it would be if we decide to expand on the underwear and sheets issue.
I understand.
That would definitely require a new expense.
But I don't think Representative Evers was speaking to that specifically. And so I'm just curious, as far as tampons and pads, if facilities are already providing them, and if you agree they fall under the constitutional definition of adequate health care, do you still believe that it could be a 28A concern to sort of delineate it more clearly in the law in this way? Thank you.
Thank you, Representative, for the question. I am a healthcare administrator. I am not an attorney. I am an aficionado of the Constitution. This is kind of in the detailed weeds of what the New Hampshire Constitution specifically would require of us. As I read this legislation, it uses the word necessary, adequate amounts as necessary for products. And the product definition is pretty broad, product designed to address menstruation. So this would be the scope of what gets covered could potentially be pretty broad. Given that there's already a constitutional obligation, I take it at your word on what you've heard. And if it's not being followed, the prisoners have an opportunity to file a civil suit for having their constitutional rights violated. But I would also think, I'd leave it to the committee, but the LBA will conduct audits. So the allegations of negligence, managerial and administrative negligence that I've heard just here are severe. And I would want the state, the executive branch, to follow up to see the extent to which the counties are violating those constitutional rights that you mentioned.
Last one.
Thank you. So you mentioned that the bill includes terminology such as necessary and adequate. It's my understanding that that's also in the section of the Constitution that speaks to healthcare for the incarcerated, that it be necessary and adequate. I guess my question is, do you think it would be less expensive for the taxpayers to pay for a civil suit loss or tampons?
I'm not going to answer that question because I think that will obfuscate my point. My point is if we're issuing a mandate from the state to the counties, and it's a new mandate, then we certainly are obligated to pay for it. And I was just suggesting that given the severity of the abuse that I've heard, we may want to supplement that with an LBA audit or ask the executive branch to conduct an investigation because I think that's just cruel. I would even go as far to say that it would be cruel and unusual punishment to deny a woman her basic health care needs.
Thank you, Representative. Thanks. No, ask him after. At this point, I would like to call Jane Graham from the Department of Corrections.
Good afternoon, Mr. Chair and members of the committee. Thank you for allowing me to testify today. I would like to testify, well, actually, I should add that Commissioner Hanks is on her way. She sent me here first in case she wasn't able to make it, but she is on her way. So if you have more questions that I'm unable to answer, she can absolutely answer them. Thank you for allowing me to speak regarding HB 421. The New Hampshire Department of Corrections supports this legislation. We currently provide menstrual products to women who are in our facilities. We currently have 136 women between our New Hampshire Correctional Facility for Women and Shea Farm Transitional Housing Unit. We provide, I want to speak a little bit to the 15 limit. We do initially give 15 products to women, but there is the flexibility to ask for more if you need them. So we don't have an actual limit as to how many that we will provide. It's unlimited. We provide 2 types of maxi pads, a panty shield product, and 2 types of tampons to women. If you've heard people talk about purchasing, we do allow people to purchase if the products that we offer aren't what individuals are looking for. Providing feminine hygiene products to our residents is the right thing to do for the health and safety of the women that we support. And it's something that we're proud to do to help support the women that we house. I want to thank you for your time today, and I will take any questions that you have.
Thank you. What is the department's policy regarding underwear for inmates?
So for women, they're issued 3 pairs of brand new underwear when at the prison. Now, I can only speak to the prison. I can't speak to the county jails at all. I don't have any awareness of those situations. Like others have said, anecdotal, but I don't follow their policies at all. So 3 pairs of brand new underwear when they arrive. Laundry service is at least 2 times a week, and it's sometimes more than that. So that's our policy.
In sheets, if sheets are stained and unable to be cleaned?
If they're stained and unable to be cleaned, then we would dispose of those.
Thank you. And if an inmate runs short of products,
yep.
Do you provide more?
Yes.
Yes. No
we do
questions
not. We do not limit. We only limit the amount they're able to have at one time. But that was not an overall limit.
Finally, for my questions, if this law were magically signed this afternoon by the governor, would it cost the department any more money?
Not at this time. It wouldn't, because it's something we already do. Again, if there were additions to it.
Indeed.
Later.
But if we were amended to underwear and this, wouldn't cost another dime.
Correct.
Thank you. Representative Newell.
Thank you, Chairman Roy, and thank you for taking my question.
Absolutely. Oh, and Commissioner Hanks can probably answer questions even better than I can, so she definitely can. Sorry.
It's afternoon. Good afternoon, honorable members of the committee. My name is Helen Hanks. I'm the Commissioner of the Department of Corrections, and happy to assist with any questions on this matter.
Sure. My question is, it seems like this is policy, this is in the Constitution. It sounds like you guys, as far as the Department of Corrections, and we're, taking counties out of this, are handling this very well. And, as far as the letter of the law, this is the policy, and it should be provided for. So I guess my thoughts go to, why is it not actually being implemented in these type of situations? And I know that these may be, anecdotal and things like that, but so, I guess what it really comes down to is accountability for people who don't abide by the policy. And, is there any way that you could speak to that, or if there have been incidents of that, and, how is that handled?
Thank you for that question. I can only speak to the State Department of Corrections, so they don't oversee county jails. And I certainly know from the collaboration pre this proposed bill that I've heard things that happen at county jails, and I assure you the department provides for this service, provides for it freely, and then even augments by allowing people to purchase more or different varieties that they might want. In addition to, just want to reaffirm, we give brand new undergarments to people coming into our facilities. We do not recycle undergarments for men or women, for that matter. And, from a perspective of, since it's not in the law at this point, there's no level in which you could go from municipal or county to county and say, are you complying with the law? And that's all I can offer. I mean, it's a well-made point, but I think the other value that might be considered is the American Corrections Association has standards for jails and standards for prisons, so striving to hit those standards would be applicable here. You're welcome.
Representative Rhodes.
Thank you, Mr. Chairman. Thank you for taking my question. So before everybody starts throwing horrible darts looks at me, I do understand that there is, I don't know the official name of it. There's that some kind of a shock that females can experience with a tampon.
Yep, toxic
So,
shock.
thank you.
Yep.
Okay. And so it's kind of a two-part. One, could that be considered dangerous in a facility? And there's a lot of talk of the wording in this is actually kind of vague for how deep we got into these weeds. So if this were to be amended, do you think that it should actually say, hygiene products of their choosing?
Representative Rhodes, I think that's a fair concern. I would say, since we're talking about the incarceration of adult females, by that time in their life, they know what product works best for them. So allowing them to make the choice that is appropriate to their experience makes a lot of sense. As an aside, if that happened in our institutions, we have the immediate first responders to come and assist as well, and healthcare in general. So if they were experiencing something else untoward, we would be able to assist.
Thank you, Mr. Chairman. So just to clarify that the wording of their choosing, you actually think would, because it doesn't say it, that's not what it says. So like I said, we kind of got into the weeds here pretty good of what it doesn't say. So I just wanted to clarify that you think that might actually be more clear if it said of their choosing, instead of just saying, hey, we gave you pads and here you go. You have your supply.
Yeah, I do think it's
okay.
I do think it's important to give a menstruating person the opportunity to pick what works best for them.
Okay. So thank you.
If I may clarify that, of their choosing between a pad and a tampon,
Correct.
not brand name.
Correct. The generalities of the, a cotton swab versus a Q-tip versus a Kleenex versus a tissue.
I just know there's a lot of different products and different prices, and it would be
There are
impossible
products,
to.
sir, that I just learned about that I didn't even know existed.
Thank you.
Leaving it broad and general is important, so that we can respond, at least from state corrections, and many of my other county jail superintendents do the same things as state corrections. So please, I don't want people walking away thinking the county jail superintendents are not all doing this. Many do.
Thank you. Representative Sitek.
I think the word of their reasonable choosing would take care of all of that. But I'd like to make a comment which I think you'll understand. I've been around this place for a while. It's unusual to see a commissioner before you. You see their second in command. And I appreciate the fact that the commissioner has come here.
Thank you, Representative Sitek. I appreciate you for that. Thank you.
Representative Bolden.
Thank you, Mr. Chairman.
I don't want to follow the law.
Thanks for taking my question. Commissioner Hanks, I was hoping the mic could be a little closer to you when you're speaking. But my question is, would you be willing, for the education of the committee in general, because we do have a lot of new folks this year, to explain the differences between the state facility and the various county facilities? Because we heard testimony earlier about, for example, Belknap was mentioned, and it might be helpful to understand whether or not that facility is under your control, and some of the experiences that people in Belknap have had, and your relationship to that, if any. And also, in explaining that, could you explain to us how you believe this legislation would impact your budget versus how you suspect that this legislation might impact the county budget? And I know that that might be a little challenging, but just a primer on the difference between county and state would be cool. Thank you.
If you could just say what's under your control and no speculation about the counties, please. Thank you.
Very appropriate. Thank you, Chairman Roy, and thank you, Representative Bolden, for that question. Probably because I haven't also had any water today yet. Simply stated, the county jails are not under the purview of the State Department of Corrections. If you're sentenced to county jail, you've received a sentence of 1 year or less for a misdemeanor crime, and or you're in pretrial detention pending sentencing on a charge. If you are at the State Department of Corrections, you have been sentenced to a felony level, 1 year or more. I balance all of this. There's this thing called pretrial credit. So you may come to us with 1 year or more, but you may have pretrial credit that gives you 6 months with us. That's really simply stated the difference between the two. Representative Bolden, there was a second part to your question. Oh, thank you for that. It will not cost the Department of Corrections any additional money, and I could not intend to speculate on the cost to the county jails because I don't know all of their varying practices, and I defer that to them.
And I asked this before you came in the room. I'll ask it again. If this law were to be amended and signed this afternoon, that mandated that you provided as requested whatever necessary products they need, and mandated clean new underwear and mandated clean sheets if they are unable to be laundered properly, would that cost you another penny?
No, no.
That is good to know. Thank you. Representative Newman.
I didn't have a question, but now I have one because I didn't think sheets were discussed here. But anyway,
could be.
For women's undergarments, when they actually submit them to be laundered, are they identified and returned to the individual? Because some of the testimony seemed to be contrary to that.
Thank you for that question, Representative Newman. All of the individuals' property is labeled with their last name, and they receive a specific unique number that is written both in permanent marker, but they're also labeled. So they, at the State Department of Corrections, their laundry is done at a minimum twice a week, and that's in addition to their base set that we provide to them for free, and then they have the ability to purchase more through the specific vendors.
Just follow up.
Yes, sir.
And does that include garments as well as the sheets? Are they issued sheets as their property?
They are issued sheets as their property, and they are numbered. It is not perfect. Sometimes they do end up with the wrong person, but the goal is that your things go in a laundry bag to the laundry that you're in charge of, and it comes back from the laundry in that bag, dried for you to take care of.
Thank you.
You're welcome.
Representative Sitek.
Of the chair, we're preaching to the choir here. The real issue is with the counties. I mean, we've not wasted our time, but we need somebody from the county. There is an association of counties. They're seem to be the people most affected. We haven't heard from them. So I'm sort of slightly put out, I guess.
I would hesitate to concur, but if I were the type to concur, I would concur. Any further questions of the commissioner? Oh, Representative Selig.
Thank you for taking my question. I'm just wondering, and this goes back to some degree to Representative Rhodes' question about if we get more specific about the types of hygiene products and preferred product style, are there any products which you at the prison level would say are not appropriate to be provided to, in terms of feminine hygiene. For example, I know many teenagers use period pants, right? Like specific underpants for that. Or people who believe in sustainability might use Diva cups, which for those of you who don't menstruate are silicone and other material cups that are inserted and capture menstrual fluid and then are removed, cleaned, and replaced.
Representative Selig, and please, new members, if I pronounce your last name incorrectly, please let me know how to pronounce it correctly.
That was perfect.
Thank you. I'm glad you brought that up because the second item was one I've only recently become familiar with, and we would not prefer a vessel that allows for the storage of blood in a correctional facility because it is can be a bloodborne pathogen as well as used as a weapon to assault our employees with. What I would prefer and recommend is if we could stick to menstrual pads and is tampon the right word? I don't know if that's generic enough. Those are the two primary products. Pads is generalized enough that it allows us, which we do, provide different heavy, medium, light, and thin, so on and so forth. Same on the tampons.
And the menstrual underwear?
We do not provide menstrual underwear. That I think we provide enough feminine products. If I could, as an aside, unique to the Department of Corrections possibly, we also have what are called resident communication committees, where myself, I go quarterly and sit with residents who are selected among their peers at all the sites to bring up topics of concern. At the State Department of Corrections with individuals incarcerated at the New Hampshire Correctional Facility for Women, this is never come up in 6 years. And I suspect even further than that. Again, it's not an issue for the department, but I appreciate the carefulness of your question. As an aside, you're talking about other property when you're talking about sheets and things like that. We have a robust property policy. I would ask politely if we could stick to feminine products in this bill. And if you were going to look at other property that's provided at the start of incarceration and during incarceration, that's a much larger topic of discussion.
Thank you, and that is certainly understood. However, the testimony we heard regarding underwear was very troubling, so it would be very difficult for us to walk away without at least examining that a little bit further. Any other questions of the commissioner? Oh, Representative Muse.
Just a quick question. If we don't change this law, could a future commissioner roll back some of the policies that you have that are currently best practice?
Representative Muse, that's a fair question, but this policy has existed even before me. Nationally in corrections, this is what you do, absent the law or with the law.
There being no further questions, thank you very much for coming again.
I appreciate it. Thank you so much.
Is there anyone else wishing to testify who is not? Oh, what? Who? Go ahead.
I promise not to ask any more questions while the commissioner's sitting there. I recall maybe in prior years that you spoke to receiving prisoners from county who had longstanding medical issues that hadn't been addressed in their county facility, and that the responsibility for addressing them fell to you because they would be in your care for so long and because you have these enhanced policies for care of prisoners. And I was just curious if you've ever received or like maybe had conversations with prisoners who were in county facilities who reported to you something related to menstruation that they experienced in county that didn't satisfy your state level policy on the matter.
If you could answer that without specifically getting into county names, that would be appreciated.
Happy to do that. Representative Bolden, that's not been something someone shared upon admission. The history you recall, I think, being more poignant, we received somebody with, for example, a broken arm from a facility that had not been mended, but not on the menstruation topic. You're welcome.
Thank you for your testimony. I will be appointing a subcommittee on this, and the subcommittee will be Representative Rhodes, Representative Salig, Representative Newell, Representative Bolden, Representative Murphy. Representative Rhodes will be the chair. Representative Pruitt wanted to be on it, but I didn't think it would be a good idea. And with that, the public hearing on HB, what was that? What was that, Bill? 1441 is closed, and we'll be in recess until 1 o'clock. Is that right? 1 o'clock? 1:30. 1:30.
Can I swap subcommittees?
Good afternoon. At this time, we will be opening the public hearing on HB 216, and the chair will recognize Representative Santanastaso to introduce this bill.
Thank you, Chairman and members of the Criminal Justice Committee. I'm here today to introduce House Bill 216 to exempt dimethyltryptamine from the Controlled Drug Act. All right. So consciousness is a strange phenomenon. It can't be explained. It's kind of hard to think about. We actually don't even know how to define it. And DMT's a substance that may be a link between the physical world and the spiritual world. So dimethyltryptamine, commonly known as DMT, is a naturally occurring psychedelic substance that's been used for centuries in traditional spiritual practice. DMT can be smoked or vaped, can be ingested as tea in the form of ayahuasca. DMT is speculated to exist in all animal and plant life, but it's known to exist in hundreds and thousands of plant and animal species. And it's also in the human body, believed to be produced in the pineal gland of the brain. So this molecular compound is extremely common on Earth, and no one actually knows why it exists or what its function is in plants and animals, because we just have no research on it. So according to the National Survey on Drug Use and Health, less than 1% of Americans aged 12 and older reported using DMT at least once in their lifetime. So DMT is just not abused. All right. And I have a lot of testimony here on actually the effects of DMT, but I'm going to defer that to Derek, who's an actual expert. So I'll just talk about freedom to practice religion. So in 2006, there was a Supreme Court case where U.S. Customs agents seized over 30 gallons of ayahuasca that was being shipped to a church in New Mexico. And the Supreme Court unanimously delivered judgment in favor of the church under the 1993 Religious Freedom Restoration Act. Chief Justice Roberts held that the government had not adequately demonstrated had a compelling interest in banning what even federal prosecutors admit is a sincere religious practice. And so there's just churches using DMT and ayahuasca in ceremonies becoming rapidly mainstream in the United States and Canada. So any restriction on the substance when intended to be used in a religious practice is a violation of Article 5 of the New Hampshire Constitution, where every individual has a natural and unalienable right to worship God according to the dictates of his own conscience and reason, and no subject shall be hurt, molested, or restrained in his person, liberty, or estate for worshiping God in the manner and season most agreeable to the dictates of his own conscience, or for his religious profession, sentiments, or persuasion, provided he does not disturb the public peace or disturb others in their religious worship. So any questions? I would actually like you guys, as far as what DMT does and how it works, I'd like you to defer to Derek. He's talked to lots of PhDs and people that know this topic and has extensive experience with it. But I will take any other questions.
If you could, regarding the religions, I'm a Catholic, and I must have missed that memo from the Pope. But can you tell me the religions that do actually use this as part of their common practice? If you know.
So there's South American and Amazon areas. The shamans there have used it for centuries. So that practice has been sort of coming to the West.
Okay. Thank you. Representative Muse.
How would you actually obtain this chemical now?
Well, it exists in most plant life, if not all, and I think it can be synthesized artificially, but I think most people actually get it from a root bark that's imported from Brazil, and they somehow mix it with some stuff and extract the actual DMT chemical.
Follow up.
So is it a commercially available drug, or is it sort of a make it yourself in your kitchen kind of a drug?
So the root bark itself is legal, as lots of plants are legal. You can go outside and pick some maple leaves and that's legal. But yeah, then someone has to actually do something with the plant to get the DMT extracted out of it. When the DMT is extracted out in its purest form, at that moment it's a controlled drug.
Representative Sitek.
You've missed two critical ingredients. Do you get high from this stuff, and is it addictive?
Yeah. So I had written testimony on this, and I wanted to skip it for Derek, but it is not addictive, and you'd have to define getting high on it for me to answer that. What does that mean?
Let me take a stab at it. Would it interfere with your operation of a motor vehicle?
I would definitely not want to operate a motor vehicle under influence of this drug.
Thank you. Any other questions? Yep. Oh. Representative Murphy.
Thank you, Mr. Chairman. Thank you for taking my question. Can you tell me for what purposes would people want to take DMD?
Like I was saying, that kind of question would be much better answered by Derek. But DMT gives us insight into our own consciousness. It takes people. Their testimony of people that have taken this substance is really bizarre. But they go to another world as they see it. And I mean, it has a reputation for being known as the God molecule because it actually will convert atheists into religious believers.
Representative Salig.
Thank you. So I just want to clarify. So it's essentially a hallucinogenic in its properties. Is that correct?
I would agree so.
Thank you, Representative.
Thank you.
At this time, the chair would recognize Derek Jozewski. I apologize for that.
Thank you. Good afternoon. My name is Derek Januszewski. I am the founding pastor for Pachamama Sanctuary. We are an ayahuasca church here in New Hampshire. We've been operating since the end of 2019. I'm sorry, the beginning of 2019. In February, we opened up. Ayahuasca is a plant medicine. It's a tea. It's generated by making tea with a leaf from a chacruna plant and a vine called ayahuasca. Chacruna is CHACRUNA, chacruna, and ayahuasca, I think you have the spelling on that. Ayahuasca is the vine. Ayahuasca doesn't have, it has very, very, very little DMT in it, or dimethyltryptamine. The dimethyltryptamine comes from the chacruna leaf, and it's boiled together like tea and drunk like tea. There's no processing that's gone on. There's no chemicals that go into it. And this ayahuasca is worshipped in South America as a medicine, and it's a medicine for the soul. It's a beautiful, beautiful teacher, and it connects us with another level of consciousness, things that we hide from ourselves. So what it allows us to do is go inside of our mind. Most drugs, like alcohol, cocaine, and opiates, they're abused so that people can forget or stop feeling something. What ayahuasca does with DMT is it allows people to feel those things, and instead of running away from them, and it's an uncomfortable process. It doesn't feel good. It's not a happy, enjoyable experience. But when we take our ego away and we can start to feel those feelings with dimethyltryptamine, with ayahuasca, it allows us to get closer to God, because our separation is not with God, it's with ourselves. And so this molecule, this beautiful molecule, allows us to connect deeply with our inner spirit and reconnect with God. It's my sacrament, and I wouldn't be alive without it. I've had about 2,000 members of my church at this point. 2,000 members of my church. And I've had dozens of men and women who have come. Some of them were addicts. Some of them were veterans that gave a lot to this country. Some of them are soccer moms that were sexually abused, and they've come to me and told me that they were suicidal before coming. They were going to kill themselves if it didn't work. And they now have beautiful lives, almost all of them. I'm in contact with them all the time. At least once every couple of months, we exchange emails. I have Zoom calls where they come. This molecule is present in almost every single living thing. Almost every animal on the planet has this in it. And it has something to do with the connection of consciousness. The molecule itself looks almost identical to serotonin, but right now, all of you have DMT in your body currently at this moment. Right now, we all do, right? Serotonin is a feel-good chemical. DMT or dimethyltryptamine has almost exactly the same makeup, so it attaches to the same exact receptors. It's just in a different way. It's very, very safe. It's not abusable. Nobody wants to take this stuff all the time. It's a very intense experience. And having that much energy and that much presence of a spiritual experience, it's something that somebody might want to do once a year. It's nothing that would make somebody want to steal their neighbor's car or a catalytic converter to get more of it. It's not like that. It's never going to be like that. It's an experience with God, and that's scary. An experience with love, that's a really scary thing. It's self-love. It teaches people to love themselves again. That's what serotonin helps us do too. It rebalances a lot of the brain chemicals like oxytocin, melatonin, serotonin, cortisol especially. So after an experience with dimethyltryptamine, people's cortisol levels drop significantly. It gives them sometimes a few days, sometimes a few weeks of a level mind. It relieves the symptoms of depression. And I would say that it does have medicinal value for sure. It's being studied right now at Johns Hopkins very, very deeply in the form of psilocybin, because psilocybin breaks down to DMT. Psilocybin turns into psilocin, and then when it gets in the bloodstream, an atom pops off and it becomes DMT. It's the same molecule. It's the same molecule. Religions around this have been around for thousands of years, as best we can tell. There's two that came from South America that are presently operating in the country. Both have had unanimous decisions from the U.S. Supreme Court. 9-0 both times, and that's Santo Daime and the UDV. These are both Brazilian churches that came here and they're operating here above board with exemptions from the DEA. The DEA has paid me a visit, and we talked about it, and they're not gonna prosecute me. It's the First Amendment protects me, but that protects me. There's other people out there that don't want to come to a retreat at my place or don't want to feel religious. And they deserve to explore their own mind, I think. That's my view. Kind of talked for a lot, so if anybody has any questions, I'd love to answer them.
Representative Murphy.
Thank you, Mr. Chairman, and thank you for taking my question. Given the effects that you've described, what's your opinion as to why the medical community isn't using this or hasn't been using this since it's well known? Why are they not using it to treat the depression? And so, given our mental health crisis that we're all saying, why would you think that if it has all those benefits that it's not being used by the medical community to help address those?
So that's a great question, and I have some opinions that I'll keep to myself, but they're currently studying it right now in a lot of universities across the country. Like I mentioned, Johns Hopkins, they're studying this deeply, and my view is that psilocybin is a lot more well known, but DMT is being studied. It's being studied a lot right now. This new psychedelic renaissance has brought on an incredible amount of study. It takes a while for that to come and be utilized.
It's free, correct?
Yes.
Representative Muse.
Do you have any medical expertise in terms of the impact or potential impact of a drug like this on somebody who not only has a mental health issue but who may also have a form of chemical dependency? So, for instance, taking DMT with alcohol, or taking it with an antidepressant, or taking it with another type of drug, which is very common among people who abuse drugs. They abuse multiple drugs. Do you have any knowledge of the potential interaction that DMT might have if someone like that used it?
I do. So the interactions with most other drugs are safe. However, due to the fact that DMT is almost a carbon copy of serotonin, if somebody is taking an antidepressant like Celexa, Lexapro, Wellbutrin, things of that nature, the SSRIs, well, then you can have a flood of serotonin, and that person can go into something called serotonin syndrome. The serotonin syndrome is an awful experience. It's very, very rarely fatal, but it's really an uncomfortable experience. It's a raised heart rate, raised blood pressure, and lowered respiration rate, or raised respiration rate. Well, since the serotonin regulates all those things, the respiration rate, the blood pressure, and the heart rate, serotonin syndrome makes them all kind of go haywire. You know, I have been around no less than 5,000 people that have taken this, and I would say maybe 100 people have been dishonest about their use of antidepressants. That's really the main one. And of those 100, I had 4 people that had a difficult experience and no medical emergencies. I've spoken with neuroscientists from Harvard about this, and multiple doctors, nurses, and EMTs to make sure that the safety of this is incredibly important. And theoretically, it can be fatal if combined with an antidepressant, but there isn't a case that we can find. The lethality of this is almost zero. As far as I know, there's been no cases in the United States that DMT has caused death.
I have a question. If, as you know, with opioids, there's a Narcan. Is there something that can bring someone out of one of these experiences if they're having an issue?
Yes, lemon and salt. It pretty much neutralizes the molecule and makes it blow apart. It's a natural remedy to a natural molecule. Lemon and salt. Mm-hmm.
Representative Newell.
I looked into this in advance and was trying to find some studies. I'm glad to hear that there are some that are in process now, so I can kind of follow up on those ones. I'm curious, with your experience, vast experience, what is your process? Since this, kind of hasn't gone through the study process and isn't currently being used medically, professionally, as far as I'm aware, what is the process that you've come to find is the right way? I mean, the amount, questions you need to ask in advance, the process for intake, essentially, of someone who is coming to you and wants to experience that.
Yeah. So for me, what I have is a medical form. I have them sit with a nurse to go over their medical form when they come. And I have a conversation with them ahead of time. I've got warnings all over the place and all of that. But I don't want to distract from the fact that my use of it is religious. The state of New Hampshire isn't all going to come to my church, right? I appreciate this bill because it's going to help me be a little bit more safe in my practice because, I mean, let's be honest, what I'm doing is not currently totally legal, you know, and I understand that there might be some repercussions of that. I believe in my sacrament so much, I'm willing to risk that. But there's other people in New Hampshire other than me and people in my church, and they should be able to explore their consciousness. They're not going to have a medical form.
Just to clarify, the reason I'm asking that question is, you know, the bill is very straightforward, right? The bill says we're going to exempt this from the Controlled Drug Act. So that means that that would, if I'm correct, that would make it completely legal for anyone to use, not through a medical professional or within the context of religion or something like that. And so what I'm trying to get at is kind of the safety precautions that you need to take, and kind of how, if it were legalized, kind of how would we ensure that other people are able to take those precautions as well?
Mm-hmm.
Does that make sense?
Yeah, I understand where you're going, where you're coming from, and I don't think that any of those are necessary. I don't believe that those safety precautions are necessary. With something like dimethyltryptamine, that I can't find a single case of a death. Cigarettes cause 440,000 deaths a year in this country. I do it because I want to make people that come feel safe, because it is a scary process what we do. This is a little bit different than what people will be experiencing on the street. Yeah.
Representative Wheeler.
Thank you, Mr. Chairman. Thank you, Derek, for your testimony. I'm wondering, what is the typical ceremony like at your church? You mentioned just now that it was a little bit more scary than it would be like on the street. What does it look like? You said you had 5,000 experiences that you had witnessed. So.
Right. So we have an indigenous shaman come to our church from Colombia, Peru, Brazil. And ayahuasca, when you take ayahuasca, it is a 6-hour, very deep journey into traumas and emotions that we've been hiding from, right? When you vaporize it and smoke it, you kind of go to another world and you come back in about 10 minutes. Okay, it's a very short and powerful experience, where the way that most people are going to take it at home. When you come to our sanctuary, ours is a long process. When you drink ayahuasca tea, it's between 4 and 6 hours, sometimes 8 and 10, but usually between 4 and 6 hours. And you're very vulnerable for a long period of time. So we have a staff of about 10 people to make sure that you're very cared for, that you're safe, that you're comfortable, a nurse on staff and all of that. And so it's scary being vulnerable. It's scary feeling feelings sometimes.
Representative Murphy.
Thank you, and thanks you for taking my question. When you talk about your staff, what are the qualifications of the staff?
Mm-hmm. I have various different staff members for various different things. You don't need a PhD to wash buckets. So we have people all up and down the scale, but I have a PhD in psychology on staff. I have multiple people that are trained in integration coaching, in addiction recovery, licensed addiction recovery. I forget what the term is, but then I have somebody who has who worked in nursing, an EMT on staff, and then multiple other people who have trained in Peru and Brazil that have worked with this medicine closely with shamans for a long period of time. In addition to that, we have people that like help people back and forth to the bathroom and don't have a very important body of knowledge. Mm-hmm.
Representative Wheeler.
Thank you. When was dimethyltryptamine made illegal? Do you know?
Thank you for your testimony. This time the chair calls Ian Freeman.
On yet? Okay, thank you. Good afternoon. Thank you for considering this important bill. I wanted to bring you up to speed. I don't want to repeat what was already said because it was really good information. I'm also a minister with the Shire Free Church. I have some personal experience with using DMT for spiritual reasons. And there was a very important Supreme Court decision. There were a few national Supreme Court decisions that were mentioned here so far, but I want to bring your attention to a New Hampshire Supreme Court decision. It came out in December of 2020. It was a unanimous decision in the case of a gentleman who had been arrested for psilocybin, which is, as you heard, a related molecule. And he was convicted at the Superior Court, appealed his case, and explained to the court, the Supreme Court, that this was his religious sacrament. And they said that the New Hampshire Constitution absolutely protects not just your right to religion, which the U.S. Constitution protects, but the New Hampshire Constitution goes so far as to protect your right to worship in the way that you choose. And so with a full unanimous vote, they overturned the Superior Court's conviction of this gentleman and set him free. So this bill would simply catch up to where the courts have already set forth. The courts have already said that the use of psychedelic substances is legal in New Hampshire for spiritual reasons. But yet someone who is not using it for a spiritual reason, or at least that's perhaps not their intention, they may end up deciding that it was a spiritual experience, but if they were just using it for a recreational purpose, I don't think that person needs to go to prison. They don't need to go to jail simply because their intentions with this molecule were different. So again, this bill would simply catch up legislatively to where we already are in the New Hampshire courts. And that's all I had. If you have any questions, happy to take them.
Representative Newman.
Thank you for taking my question.
Sure.
You just mentioned another substance that the Supreme Court in New Hampshire Supreme Court said was legal based on the New Hampshire Constitution.
That's
After
right.
that ruling, was that removed from the controlled drug list, or is it still on the list? Or had it ever been on the list?
Yes, it's absolutely on that that list. Unfortunately, last year there was a bill that would have decriminalized psilocybin mushrooms, and I don't think it made it out of committee, unfortunately, as far as it was not given an OTP. It should have been, because again, that bill and this one would have caught up legislatively to where the courts already are. But usually the legislature, as you know, takes a long time to get anything done that should be done.
I didn't know that, but thank you.
Okay, now you know.
Representative Newell.
Real quick. I am not fully caught up on my email. I think I'm about 24 hours behind. Have you submitted that the Supreme Court ruling, the briefing? Because I think that would be really helpful.
No, I haven't, but I'm happy to do that.
Great, thank you.
Sure.
Thank you for your testimony.
Sure thing.
The chair recognizes Joshua Holmes.
Hello, and thank you for being here to hear this testimony today. I had the good fortune to go to college on the GI Bill, and so the government paid for me to read books for 4 years. And one of those books was the Epic of Gilgamesh, which is the oldest version of the hero's journey that we have in surviving text, something like 5,000 or 6,000 years old. And in that story, the hero of the story goes through the flood of the Bible, but from a different perspective. And he utilizes the drug that is ayahuasca or DMT to journey to the spirit world and to resolve the personal issues that had made him a tyrant king and allowed him to be a complete person and to rule his kingdom with justice. this same chemical is found in the acacia bush, which is the burning bush that we know from the Bible that Moses saw that allowed him to speak to God. So it is general knowledge that the purpose of this drug is to allow you to achieve a religious experience. I just wanted to make that clear. That's something that I got out of my undergrad degree. If anybody has any questions about these stories, I don't know anything about using the drug personally, but I could tell you about the meaning behind the stories. I got the degree in it.
There being no questions, thank you.
All right.
Thank you for
Thank
sharing.
you for your time.
The chair recognizes, I believe it's Reverend Gabe Lay Holden. Holdren?
Yeah, Reverend Gabe Lee Holdren. So there's an incredible amount of medical utility to this substance. To put it in recognizable terms, it's dreams. It literally exists in the pineal gland. It's released in small quantities during dreams, large quantities during near-death experiences. You're making something illegal that you are all currently carrying around inside the middle of your head. That's absurd. And there are a lot of people who bring their lives back together because they have some of this. It has tremendous effects on PTSD, and we have a lot of veterans that could really use a bit more sanity. It's incredibly effective at treating other drug addictions, especially the opium epidemic that we have now could be drastically improved from it. I don't know which is more absurd. The fact that, oh, by the way, it's in all your groceries. Like, we'd have to put away every grocery store owner if we're going to actually enforce this. It's absurd. The thing about this molecule, it gets digested incredibly easy. It's why you have to do this special tea to get you to not digest the thing. It's in everything. It's in everything that's alive. I'm happy to take any questions.
Seeing, oh, yep. Representative Muse.
I did have one question, you know, given...
Oh, sorry. One more thing I wanted to do. The illegalization, as I understand it, it was in a swath of when LSD was put on the drug list to they'd seen this massive social change. So they're like, clamp down on that. What are they doing? LSD, put that in there. What's this? That's also one of these. Okay, put those all on the list. As I understand, that was the only real thinking on this thing in the first place. Sorry.
Sure. Given the fact that it seems like the drug is manufactured, maybe not by the people who use it, but manufactured locally for the people who do use it. One of the things that I'm curious about is people who have addiction issues, mental health issues, PTSD issues, taking a powerful drug that, if you're taking the wrong antidepressant, has the risk of actually killing you outside of a clinical setting. What is your ability to actually help people who get into not just mental distress, but actual physical distress in your places of worship?
What do you mean physical distress?
One of the things we heard earlier was there actually is a risk of death due to a serotonin
yeah,
reaction.
it's you can overdose on it, like very many substances. I mean, enough water will kill you, and that's the thing. The way that it's made, there are two substances. One it has a heavy dose of this thing that's in everything, and the other gets your body to not digest it. So the drugs that you're referring to are this side of it. So you're just overdosing on it. So it's like, oh, don't take a bunch of alcohol when you've been taking a bunch of alcohol. Yeah, the difference between dosage between poison and medicine is always in the dosage.
Oh. I'm not sure you answered my question.
Oh, I'm sorry.
How are you prepared to actually take care of people who may have an adverse physical reaction to the chemical?
Oh, well, I don't run a church for this. I will vouch for everything that's been said on that, but so personally, if I was going to, and I suspect that he probably has this, there are ways of diluting that effect. There are things you can take. The first thing I would be like, okay, get them some water. But like, I'm sure he knows the chemistry far better than I do to tone this down. So it would be, yeah, absolutely. If you're going to run a business or a church that does this, it would be prudent to have some on hand. But anything that you have too much of is going to kill people. And the thing with this is because it's illegal, it's not dosed out. Like it doesn't come in nice little here's your dosage because it hasn't been able to be put on shelves. So we don't have this in its proper dosage. Yeah. Oh, similar to aspirin. If you take a bunch of aspirin, yeah, it'll be a blood thinner, and if you're already on blood thinners, then that can kill you.
Representative Wheeler.
Has this ever killed anyone?
I don't know.
Thank you for your testimony today. Chair recognizes Jason Gerhard.
Thank you, Chairman. Thank you, members of the committee, for hearing this bill. My name is Jason Gerhard. I represent Northfield Franklin, Merrimack 25, and I'll keep this short. We obviously are in the throes of a major opioid addiction epidemic, and the current, so let's put it this way, a large proportion of people who are incarcerated suffer from addiction issues. That should be kind of self-evident. The way of treating this is by giving them other drugs, so most namely Suboxone. Now, Suboxone is an opioid blocker. The problem is you can get high off of Suboxone. So it's just a mess. It seems like we're substituting one thing for another thing. When we go into the psychedelic realm, people are taking this drug once and overcoming their addictions, or at least coming to confront the issues that drive them to their addictions, which I think is key. We're looking at the dangers of this as if it's somebody doing it every weekend, which it just doesn't happen. It's like psilocybin with mushrooms, you know. It's just not something that people do like that. Or if they do, they're just burnt out and they're going to be the same people huffing paint. I mean, what are you going to do, ban paint? So my point being is that if we really want to deal with the addiction issues, we have to kind of look to something that's actually been used in the past to cure them. Just real quick, Aldous Huxley, back in the 1950s, he wrote Doors of Perception. That's actually where the band The Doors got their name from. But in it, he was talking about his mescaline experience and other psychedelics. And shortly thereafter, they banned all that and canceled all the research. So we've kind of been in the dark ages of a lot of this stuff. So at the very least, if you guys do decide to ITL this or whatever, at least in the future, or somehow amend this somehow, at least open up some kind of ability to investigate and start some trials at the state level so we can actually see what's really going on here. We have plenty of people locked up. Why not? You know, I mean, let's just try to figure out, we got to do something, because locking people up's not working. What are you going to make stuff more illegal? I mean, it's already legal. So it's like, so anyway, I'd be glad to take some questions.
Seeing none, thank you for your testimony.
Thank you very much.
Chair recognizes Mr. Frank Staples.
Thank you. I'm going to try to touch on a few things, and I will credential myself. I spent 5 years in solitary confinement, 2.5 years for refusing to shave my beard on religious grounds. So I do understand the First Amendment and what this gentleman should be referring to is not the First Amendment because it's less protective than ours. Article 5 is religious freedom recognized, which Ian Freeman testified to, protects the right to worship. So I also understand the clinical concerns, and I would recommend people to go to maps.org. That's the Multidisciplinary Association for Psychedelic Studies. It's a 501c3 government funded. They do a lot of PTSD studies with they're the ones doing all this PTSD studies with the veterans and drug addiction and stuff like that. I'm actually trained as psychedelic peer support specialist. I would suggest the gentleman putting forth the bill to have all his staff trained as psychedelic peer support specialists as well, if they're not already. He may have mentioned that, I'm not sure. I came in a little bit late. But I think there's a two-pronged approach here, and if this bill was to make all substances, for religious purposes, because that would cover everything, the mushrooms and all these other. There's another one called ibogaine, comes from the plant iboga. This is specific to the opioid crisis, and there is a contraindication with this one as well. You got to be careful and make sure you're not taking something that you're not supposed to, like an SSRI when it comes to DMT. But ibogaine is specific to the opioid crisis. People take a dose of this. They go into, a 6 hour, they're in a closed room by themselves. They deal with all this trauma. They come out and it also kills any withdrawals. If you're having withdrawals, the withdrawals immediately go away, and then they come out, and sometimes in 6 months they might do a revisit, but most people take one dose of this ibogaine and it cures the opioid crisis. I think it was Rep. Murphy was wondering, why isn't this stuff being used? Well, it is being tested and it is being used because they are seeing how powerful it is. The problem is big pharma is all they want to do is push pills that you have to take forever. Okay, ever since the opium wars, every cure has been a stronger opioid. Okay, they had opium, then they created morphine. Morphine became hydromorphone, which is heroin, and then it methadone and all these fentanyl, and it's just a stronger and stronger opiate to cure the opioid crisis is not working, and we need to change that. So I think that if this bill was passed, it would also expand the clinical usage and the ability for clinicians to apply with MAPS, and people should have the right to go through a clinician and get it done, but they should also, and they do have the right to go get it from his church or whatever. And yeah, there are dangers. There are people who hold rattlesnakes, and they're allowed to do that, right? There are people who die in sweat lodges. Okay, so these things happen, and that's a part of people's spirituality, and we have that right under the New Hampshire Constitution, Article 5. So let me make sure. Yeah, I do think that all drugs should be exempt from any religious practices. It would just really streamline that and fall in line with the Supreme Court decision there. So that's it. If anyone has any questions. I'm also I do work in the recovery community. I'm this local coordinator for Smart Recovery. I operate Humble House LLC. It's the only alternative to the 12 steps.
Thank you. Representative Newell.
Hey, Frank. Actually, I think a memory just came up. You and I speaking on a panel together about substance use disorder. So
Yes,
I
I've
recognize
spoken
you. I
on
don't
a
know
few
if you
panels.
recognize me.
Thank you.
I was actually first going to say, it would be good to say that so that people understand where you're coming from.
I appreciate that.
And given that, I'm curious, when you're talking about ending withdrawals and like its utility as a treatment in substance use disorder, is that, well, I guess first of all, is it opiate use disorder or all substance use disorder that it's good for? And then second of all, is that anecdotal or is there some type of reference to?
There are studies. I would suggest going to maps.org, and there are plenty of studies there. You can look at all the different ones.
look up ibogaine opioids. If you Google it, I'm sure there'll be plenty of stuff that comes up. It is used for other things, smoking and alcohol as well, but it particularly stops the withdrawals of opioids. And, you know, people come out, they've worked through all this past trauma without a therapist. They've done it all in their mind, right? Like it's like a dream world that you go into, and you're not a danger to yourself. You can go and get these treatments. I know a guy, a friend of mine, he's got the money. Took him $5,000. He had to go to Mexico to get iboga treatment. He was doing like 5 grams of heroin a day, you know, and he went and he did this iboga treatment and it worked. But most people, and especially the homeless people, they can't do that. And you can get this iboga and the ibogaine. It's readily available. It comes from plants. We can make it. We can mass produce it. People can produce it on their own, and we can really get to the heart of this issue. But again, it's big pharma and these lobbyists who are keeping this stuff from happening. It's all about billing insurance. Even the recovery community, these recovery houses, they send people into treatment, then they come out. I volunteer at Hope for New Hampshire. I think I mentioned Smart Recovery. I asked them, what tools did they learn? You were in rehab for 30 days, 6 months, 90 days, whatever it was. They weren't taught anything. They go to these little group meetings and individual meetings, and they get billed insurance. They get sent out, put in, and then cycled back through. It's disgusting. It's absolutely disgusting. And all the money's getting funneled through this, this recovery housing coalition. They got to certify these houses so all the money can get funneled to these houses. That's a conspiracy too, and that's not okay. That's all, one hand washing the other. These people doing favors for their friends. And are we going to solve the problem, or are we trying to line everybody's pockets? That's the question.
Thank you. The chair recognizes Bonnie Freeman.
Hello, my name is Bonnie Freeman, and I'm a minister at the Shire Free Church as well. And I just think it's interesting that 4 speakers, including myself so far, have all been ministers of some sort. I think it's interesting because I was actually an atheist for a long time, and Minister Holdren, I'm not part of his church or anything, I was just talking to him, and I would consider it ministering to me, really helped me to realize that even though I didn't believe anymore in a God up in the sky judging everything I did, because I grew up Christian and I broke away from that, didn't mean that I hadn't seen any evidence of God before, and I just had to think of him differently, sort of. I just wanted to put that out there because I think it's interesting. All of us have had experiences with this molecule, DMT, and it helped open our eyes. Well, I can speak for myself in this part. It helped open my eyes to a loving presence that's out there and also in everyone, that I call God. So I just wanted to throw that out there. I thought that was interesting. Basically, I take DMT once in a while, and the government making it illegal in 1970, to answer your question, doesn't stop me. All it does is put me at risk for harm by the hand of the government by utilizing my natural right to put into my body whatever I want. But it's not going to stop me, so the laws against it are at the very least not effective. I've been diagnosed with PTSD, and I work with my dreams a lot, and almost 2 years after the incident that gave me PTSD, I have dreams that I interpret as my brain still trying to understand what happened to me. But during a time that I took DMT, I wouldn't say that it cured me, but it's helped me to change my perspective on what's happened, and even look at the people who are persecuting me and my church and my husband with love, like the people that I should want to hate. Like, it's helped me change my perspective, and realize, basically, I've only taken it in the vaporized way. I've never taken ayahuasca, so that's a big distinction. I've never taken a 6-hour trip, and I don't even think I would describe what has happened to me on DMT as the furthest that you can go, which like people call it blasting off. I don't think that that's happened to me. I wanted to explain in just real terms what it's like. It's like you take it and you start to feel really nice right away. Like you don't feel nervous. I've told some other ministers of mine that were thinking about taking it and then did take it because I recommended it as a sacrament, that with marijuana, which lots of people are way more familiar with, you can easily just start to feel nervous, and you don't get that with DMT. You just it feels like somebody's there just giving you like I don't know how to explain it, except for that you feel very relaxed and nice. You don't get all crazy and feel like you're out of your mind or feel uncomfortable when you're taking in the vaporized form. I've never experienced ayahuasca. But basically, you just start to think of things differently, and maybe you'll see beautiful patterns. Usually, that only happens to me when I close my eyes. So it's not like if I had my eyes open, I would be seeing a pattern. But I know people that does happen to them. But things will look different and feel different. So in a dream, a real dream when you're sleeping, you can kind of know a thing, and that will happen to you while you're awake. Like my dog, I have a Chihuahua, came up to me, and while I'm just in the middle of this, and he comes up to me and is just looking at me right in the face, and I just knew that he was just saying that he loved me. It sounds kind of weird, but in a dream, something like that could happen, and it's just like that. It's senses that you don't have in your regular waking state that you have access to on DMT. And I just want to say that because I felt like lots of people were kind of talking about it in a really around the subject kind of way. Just wanted to explain exactly what it's like. It's not like being on marijuana where everything is silly and you feel paranoid and your heart rate's beating really hard. You feel very comfortable. At the most, I feel a little heavy, like sitting down feels nice. And that's it. That's all I wanted to say.
Thank you very much for sharing with us today.
Thank you.
This time, the chair recognizes Captain Bill Boyd, the New Hampshire State Police.
Thank you very much, committee, for hearing my testimony. My name is Bill Bright. I'm a captain with the New Hampshire State Police. And this bill, as it's proposed to legalize DMT, our concern is obviously with the public safety of the citizens of the state of New Hampshire. It's classified as a hallucinogenic drug, as it has been testified to. This is also a Schedule I drug, which makes it illegal federally. Our concern would be that with it more readily available to the public, there would be more widespread use, which would lead to more impaired drivers, more access to children, and not necessarily for the people who are taking it, but for the others that may be affected as a result of their use of this drug. So for those reasons, we would oppose the bill as it is written.
Representative Pearl.
So to the fact of people driving, is there a test to determine if this is in their system, how much is in their system, and are they under the influence while they're driving?
It would be just regular impairment that an officer would be able to detect. But as far as a test to determine this drug, other than a drug recognition expert doing an evaluation, I'm not a drug recognition expert, so I can't testify to what those indicators would be that would help them determine what type of drug a person is on. But other than that, no, there's no test that I know of.
Representative Selig.
Thank you, Mr. Chairman. Thank you for your testimony. I'm curious if the law as written were amended to say that it was to be removed from the Controlled Drug Act explicitly for clinical or religious settings, would that make any difference to perspective? I'm just wondering, like, perspective-wise, if it's used in like a set safe zone type of thing, does that change the nature?
As with any amendment or any bill, we would have to take a look at the wording and make a judgment call at that time. So I'm not sure how to respond to that.
Captain, if you could tell us, are you aware, is this readily available now? I mean, is there a black market for it currently available?
This is nothing that I've come across in my career. To my knowledge, it's not seen often. Obviously, there's been testimony that it is available in different forms, but it is not something that I've come across personally, and I don't know of any current cases.
Representative Wheeler.
Thank you, Mr. Chairman. Thank you, Captain Bright. How many people are pulled over per year, if you could follow up with this number if you don't know it off the top of your head, in regards to who are high on hallucinogens? I'm not aware of those statistics. I can look into that for you if you would like. Anecdotally, would you say a lot of follow up, Mr. Chairman? Sorry, still getting used to this. Anecdotally, would you say that there are a lot of people who are pulled over who are on a hallucinogenic substance? Well, as you know, I mean, an officer won't be able to determine that at the time that they pull somebody over. They would be looking for impairment. That the numbers I'm not aware of. I don't know how many people are pulled over for hallucinogenics. I can look into that for you, though.
Representative Sitek.
Captain, I think your objection, as I hear it, is the same as your objection to marijuana. It's what the effects on driving, is it not? I don't see any other issues that you've raised.
Well, there could be many other effects as far as it's my understanding that a person who is under impairment of this drug specifically, it's unpredictable high, I guess, so to speak. Like, no, I don't believe that anybody knows how it's going to affect them ahead of time, or how long or anything like that. So a person who is under the influence of, say, this drug that for an extended period of time may come across many different situations. And in an altered state of mind, we would be concerned about the safety for them and for other individuals that they come in contact with while they're under the influence of this drug or of any drug.
Representative Newell.
Thank you, Mr. Chairman. Could you speak to, I guess the implications of it being, of course, federally, it's Schedule 1 drug. If it were legalized as written in the state, what would be the implications of it being federally illegal and legal in the state?
A person would still be subject to the federal penalties if they were charged federally for possession.
Can I follow up? Okay, so you're here on behalf of the state police, right? So
That's
state police, that's under state jurisdiction. So if it were a federal law enforcement, that would be dealt with federally and on the state
That's correct.
level.
Or if the federal law was broken, they could be charged in a federal court.
Okay, thank you.
Thank you, Captain.
Thank you.
Is there anyone else wishing to testify on this bill who has not done so?
I would just, Derek informed me he has additional testimony to clear a few things up, and I'd just ask as a courtesy. He's the expert that I asked to be here for this. So I think his testimony would be extremely valuable if you would allow that.
Actually, I'm late for my next bill, so I will not allow that, but I would welcome him to email us and if he wanted to rebut what he heard. Generally, we don't take rebuttal testimony, so I'd be happy to, you can email the whole committee and we would take a look at it.
Thank you.
Thank you. At this time, I'm closing the public hearing. And I'm going to open the public hearing on HB 144FN and recognize who? Our Rep. Gerard. That guy was the one who made me draw my gun. He's no. Good. Well, if I miss, feel free to.
Thank you, Chairman. Members of the committee, here again. My name is Jason Gerhard, representing Northfield Franklin, and here to speak on restoring firearm ownership rights to ex-felons, non-violent ex-felons, emphasizing the non-violent part. I had testimony submitted from several people. Unfortunately, I did not bring printed copies for you. I would like to submit emails afterwards. I'll forward them. I just want to address one real quick. It's very short. Where, okay, this is a resident of Manchester, which, as you know, is not high crime, but definitely not low crime. So she's a single mother, 2 children. And she writes, "My name is Molly Mae Washington, retired Army combat veteran, currently a registered nurse at the Veterans Administration. In 2015, I served a 3-year state prison sentence for a nonviolent financial crime, embezzlement. Restitution will be paid the remainder of my life. I own a home in Manchester, New Hampshire, and have 13-year-old twins. It is not safe. I contacted a lawyer, Penny Dean, in an attempt to restore my rights a year ago. Current law prevents my Second Amendment rights from being restored so long as I owe restitution. I am off parole and have satisfied my sentence. Please revise the law to allow non-violent felons Second Amendment restoration upon completion of their sentence. We shouldn't have to pay a lawyer $6,000 to accomplish a constitutional right." It was unknown to me until very recently. There's actually a cottage industry in New Hampshire where we have attorneys that help people get their gun rights back through the annulment process and so forth. So there's obviously some opposition to this bill on that ground, which I can understand. But point being is, if someone is done with their sentence and they qualify under the annulment situation we already have in state law, I see no reason why we should have to file a bunch of paperwork and expend a lot of money in order to defend ourselves and our families. We already have the Second Amendment right. I'm sorry, not Second Amendment, New Hampshire. But we have the right to bear arms, to protect ourselves and our property. And so I'm an ex-felon myself, nonviolent. I served 12 and a half years. I'm about to be done with probation here in a little bit, a couple weeks. And it's hard for me to understand how we can have a state representative, this is my situation, obviously, but we can have a state representative who cannot defend himself. So if I'm going out into the parking garage late at night and somebody yells, "Hey, sweet cheeks," I'm just joking around. But if somebody, there's no way for me to defend myself. I mean, I have a knife, but come on. And it just doesn't make any sense to me, especially now also we have women. And that's another thing with single mothers. And I don't know. It's just so hard for me to explain everything in the sense of the absurdity of it all. If you're done with your sentence and you're non-violent, you have no predisposition to violence. What are we doing? Really, all we're doing is funneling people into the court system where they pay obscene amounts of money in order to regain a right that they were born with. The last point that I want to make, getting a little tripped up here in my mind. Okay, we got some camera action. I just think that it's important to recognize everybody's life as equal. And I just don't see why we should say that you have the ability to defend yourself and you don't, especially when these people have shown no violence towards anyone else. I don't know. I'm just confused about this whole thing. So any questions, I'd appreciate it. I did have more to say, but I'm getting tripped up now. So I'd appreciate it. Thank you.
Thank you. What is your understanding of we have these two tiers, the federal prohibition on felons possessing firearms versus the state? In other words, you're asking for us to take care of the state portion of it. In your understanding, would that get rid of the federal part too?
No, as far as I'm concerned, the state's sovereign, as are the people. And I'll deal with the federal part of this. Let's put it that way. I have another bill in to deal with any gun made within the confines of Montana. I keep saying Montana. That's where the law originated in 2008. Any gun made within the confines of the state of New Hampshire is not subject to federal jurisdiction. The Interstate Commerce Clause has been extended to encompass everything. The whole game is concentrate power in D.C., which I think is really detrimental to everybody in this state, especially considering Article 7, state sovereignty. But hopefully that answers your question.
It does. Thank you.
Thank you. In my mind, violent crime and drugs go together, and I don't think I could find myself supporting this unless we amended it to include nonviolent or to consider drugs as a violent crime. If you're talking about embezzlement, I don't objection to that. But how do you feel about the include considering drugs as a violent crime. And by the way, your probation lasts 2 years. Okay, you got elected for 2.
Oh, you're saying stay. Yeah. I was like, hold on, no. As far as drugs go, I think we'd be crossing into a very dangerous territory. So let's go back to my whole little prison stint. What are we going to do with alcoholics? What are you going to do with people huffing propane? I didn't even know people huff propane. I found out when I was campaigning in Franklin. Somebody told me somebody exploded down the street years ago on it. But there's just so many addictions that to just try to say, okay, these illegal drugs, like we just heard on DMT. We just heard that. So if somebody gets caught with DMT, we're going to take their right to defend themselves and their families away from them. Now you can say, well, they could be violent. There's a lot of things that could happen. You're a man. You could be violent in the right circumstances. I think we need to judge people by what they have done, not what they could do or might happen in the future. It's just, you know what I'm trying to get at? It just gets very dangerous. For instance, marijuana was considered the most dangerous thing ever. And now recently, look at Colorado, everybody just kind of gave it up on it, except for New Hampshire. But they just kind of realized the writing on the wall and just kind of accepted what it is. I don't know if that's answering your question exactly, but I just don't want to delve into that territory because it just seems like tomorrow, if marijuana is legalized, what are we going to do? Now restore all their gun rights? It just...
Thank you, Representative. Thank you for your testimony.
Thank you very much.
This point, the chair calls Representative J.R. Hole.
Hello, Chairman, members of the committee. Representative J.R. Hole, Dunbarton, New Hampshire, former member of ED&A. So my good friend up here, Representative Sytek, is going to understand what I'm about to make as an argument. We do have a lot of non-violent felonies. If you pull up the chapter on occupational licensure, it shows up about 90 times. Landscape architect, doing forestry. I'll pick on the field that I'm in, engineering. Okay, if I do engineering and I do it under a DBA, it's no longer a natural person. It falls under, right, a doing business as, which means it's another entity, which means instead of a misdemeanor level offense, it's a Class B felony. Restoring the rights of citizens who haven't hurt somebody, okay, is an important thing. And I'm here as a board member of New Hampshire Firearms Coalition to talk about long-term, we've misused the term felony in a lot of our statutes. This may be a Band-Aid to start fixing that. The correct thing would be to, use felony for violent level offenses. We don't. We use it for a lot of things. And occupational licensure is the one place, and I can send the committee the list of places it shows up between section 308 and 322. There's a lot of them as a penalty. Citizens should not be denied their natural and constitutional rights because of archaic and complicated laws and something as simple as a failure to pay a $100 licensing fee. Right, if prosecuted, rarely does that happen, but if prosecuted, could put you in jail. So with that, I'll close my testimony.
Thank you, Representative.
Thank you.
The chair recognizes Mr. Frank Staples.
Thank you again.
Deja vu.
You can see I am armed. I am an ex-felon. And I believe that I am not a felon anymore because of New Hampshire RSA 607A. That is the Uniform Act on the Status of Convicted Persons. Okay. So whether or not my crime, my felony was violent or not, once my sentence is over, the state statute automatically gives me back my 3 core civil rights: my right to vote, serve on a jury, and hold public office. The federal firearms statute, this is a frequently litigated issue. This comes from 1435 Post-Conviction Restoration of Civil Rights. This is federal. A frequently litigated issue under 922G1 is whether a convicted felon is exempt from the prohibitions of the statute because of a post-conviction restoration of civil rights under state law in accordance with 18 U.S.C. 921A20, which gives an exemption if a conviction does not disqualify an individual from possessing firearms if the person convicted has had civil rights restored. In 922G1 cases based upon state felony conviction, courts have uniformly looked to the law of the state where the conviction was obtained to determine whether the defendant's civil rights have been restored and whether such action has nullified the conviction's incidental prohibition on firearms possession. With respect to felony convictions, the Supreme Court declared in Beecham v. United States that only federal law can nullify the effect of the conviction through expungement, pardon, or restoration of civil rights. This is so, the court ruled, even though there is no federal procedure for restoring the civil rights of federal felons. Okay, so it's different for federal felons. In United States v. Ramos, the court held that the term restored requires the state to make an individualized official judgment that the defendant should be accepted from the provisions of 922G1. The criminal division takes the position that where the state law contains any provision purporting to restore civil rights, which 607A does, either upon application by the defendant or automatically upon completion of sentence, it does automatically in New Hampshire, it should be given effect. It is not necessary that the state issue an individualized certificate reflecting the judgment of state officials regarding an individual defendant. The Ramos case should be limited to its unique facts and not extended to attempts to nullify the effect of other state schemes for civil restoration. A state restoration document that is absolute on its face should disqualify the affected state felon from prosecution under 922G1, the federal statute. So if it's going to preclude them from prosecution, so I'll be precluded from prosecution for holding a firearm under 922G, then how can the state convict me for being a felon in possession if the feds are relying on this state statute to determine that I'm not a felon? So I posit that the certificate of discharge 607A5 gives us back all our civil rights. We suffer no civil death upon completion of our sentence. Once we have no restitution, we're not serving probation or parole, which I'm not. I'm completely off paper. So it's my understanding in my interpretation of the law that I'm not considered a felon. The problem is this 607A, it defines what a felon is, but it doesn't explicitly state it. Nowhere in the state law is felon defined. Felony is defined. Sure, a felony is defined, and violent felonies are defined, and nonviolent, you can't turn nonviolent things to violent. I mean, that's pretty crazy that this guy's even suggesting something like that. I will say that. That's absolutely ridiculous, and you should retire or something.
Sir, you want to keep testifying?
Yes.
Then keep it to that.
So whether it's violent or nonviolent, once someone served their conviction, then they're no longer considered a felon. But so I would say that 607A backs up, that chapter backs up this bill, and it just needs to be clarified that and the annulment statute needs to be repealed. There's no need for an annulment process and statute to have to pay for the lawyers because 607A already gives us back our rights. But it's very, very sophisticated language that you have to decipher to gather all this. I can read right here the certificate of discharge. If the sentence was imposed in this state, the other instrument, blah blah blah, completion of after completion of service of his sentence or after service of probation or parole, shall state that the defendant's right to vote and hold any future public office of which he was deprived by this chapter are thereby restored, and that he suffers no other disability by virtue of his conviction and sentence except as otherwise provided by this chapter. And nowhere in this chapter does it say that you're not allowed to have a firearm. In fact, the right to bear arms, which supersedes the federal Constitution, this is the New Hampshire Constitution, all persons have the right to keep and bear arms in defense of themselves, their families, the property, and the state. So I would like to be able to carry a gun. I carry knives all the time, and I've defended myself with a knife legally. I've never assaulted anyone. And I would like to, like Rep. Gerhard, be able to have a gun in case I need to stop a mass shooter, which has been done in certain places. There are a lot of crazy people out there, and it's right here. It's protected in the state constitution and RSA 607A. So I figure maybe I'll go out and buy a gun today.
Thank you for your testimony.
Thank you. Any questions?
No.
He has one.
I have a question of the chair. We've just heard an explosion of RSAs. I don't know what he's talking about. Can we get an opinion from the Attorney General whether he's making sense?
Oh, I'm making
Absolutely.
sense. RSA 607A. I'd love. Would that be public, sir? Would I be able to get a copy of that? If he pulls, I would love that.
From the Attorney General?
Yes.
Yeah. Anything they produce.
I would love his interpretation on RSA 607A. I've already tried to get it. Thank you.
Attorney Stephen Enders, please.
Good afternoon. My name is Stephen Enders. I'm an attorney with the Merrimack County Attorney's Office. I've been a prosecutor for a little over 20 years. With reference to guns, it's sort of always a hot button issue and people have very emotional responses either way. But the fact of the matter is, no matter how you feel about guns, the way it is in New Hampshire is you have a right to bear guns and firearms unless there's a specific legislative act that prohibits it. The current statute, RSA 159.3, is exactly one of those statutes. It sets forth a category of people, and that category of people are people that have been convicted of felons against the person or property of another, or drug felonies, and it sets forth a penalty, which would make it a Class B felony for those individuals to possess firearms. When I look at this bill, one of the things that strikes me is the first part of it repeals RSA 159.3. So it would repeal that category of persons as well as the prohibition, making it a Class B felony. And it replaces it by saying people convicted of felonies that did not involve committing an act of violence shall have the right to possess firearms. With reference to felonies that did not involve an act of violence, it makes me wonder what that means. I hear the term nonviolent felons, but I would assume that for a felony to involve an act of violence, it would actually have to have an act of violence as an element of that felony. And the bill defines act of violence as physical harm inflicted upon another individual. There's actually not a lot of felonies that have an element of physical harm inflicted upon another individual. For example, burglary is a property crime. There's no element of violence in burglary. Arson is a property crime. There's no element of violence in arson. Kidnapping and stalking don't have any elements of violence within their crimes, so I guess those would be considered nonviolent felonies as well. Aggravated felonious sexual assault doesn't have an element of physical harm in it either. So all of those things don't have an element which requires a person to be injured. Statutes that require a person to be injured, for example, the murder statutes, first-degree assault, second-degree assault, the only drug statute that I can think of that has an element of physical harm is the death resulting statute. But essentially, all of those statutes where there isn't an element of physical harm wouldn't come under the language in this amendment. The other thing that I notice when I look at this in section 1 is there's no penalty provision. So as I read it, it says if you're convicted of a felony that didn't involve committing an act of violence, you have the right to possess and use a firearm. But what if you're convicted of a felony that did have an element of violence? It wouldn't be a Class B felony anymore because we would have repealed 159.3. So it would essentially open it to all felons, whether you are convicted of a violent felony or not. I also think it's odd that the statute itself says that you have a right to possess and use firearms. As I had indicated earlier, essentially everyone has a right to possess firearms unless there's a legislative act that restricts you from doing so. We don't need laws that specifically say this group of people has a right to possess firearms. And I think writing a law that says this specific group has the right to possess firearms becomes confusing because there's other laws that restrict the use and possession of firearms. For example, you can't discharge a firearm within 300 feet of a permanently occupied dwelling. That goes for everybody. But if you're a convicted felon and you have the right to possess and use a firearm, does that law apply to you now? Or does this law trump the one that says you can't fire within 300 feet of an occupied dwelling? It also, for example, in New Hampshire, if you're the subject of a protective order, you're restricted from possessing firearms. If there's a law that says specifically that a certain group has a right to possess firearms, and if there's another law that says if in fact there's a protective order issued against you, you don't have the right to possess firearms, which law wins in that case? It's also worth noting, as indicated earlier, federal law still prohibits people convicted of felonies of possessing firearms. So even if we were to get rid of 159.3, it would be a federal felony to sell somebody a firearm if they were a convicted felon, and it would be a federal felony to possess a firearm if you were a convicted felon. So it's not like you could go to your local gun store and legally purchase a firearm, even if this bill were to pass. Looking at the second section of House Bill 144, it talks about armed career criminals. And again, this suffers from sort of the same difficulty. It says an offense that involves an act of violence or threat of violence, and then defines that as bodily injury or the imminent fear of bodily injury. But again, I presume that would have to be an element of the crime, and there's very limited crimes that actually have that as an element. There's a number of enumerated felonies in the second section, one of which is arson. But again, arson doesn't have an element of bodily injury or imminent bodily injury. Arson is a property crime. So it makes you wonder, how many arsons could you have before you became an armed career criminal? And frankly, I think you could have as many as you wanted because there's never an element of violence in an arson case. Same thing with burglary. There's no physical harm or threat in a burglary. It's the crime of breaking into someone's property with an intent to commit a crime within that property. So theoretically, you could have as many burglaries as you wanted and still possess firearms. Same thing with robbery. There's a version of robbery that does have bodily injury, but generally, robbery is not a crime with that element. Child sexual abuse images, there's no element of violence in that crime. And then looking at the third section of the bill, House Bill 144, it amends the exceptions provision in 159.5, which currently says 159.3 and 159.4, to just bring it to RSA 159.4. So law enforcement would be exempt from RSA 159.4, which makes no sense at all to me because RSA 159.4 was actually repealed in 2017. So it would reference a statute that no longer exists and say that this group is exempt from this statute that doesn't exist. So I think there's certainly the philosophy of allowing felons to have guns, which I would not be in agreement with. But if you did adopt that philosophy, the language in this bill certainly, in my opinion, doesn't get you there. So that's why I'd ask that you find it inexpedient to legislate. Thank you.
Representative Sitek.
You're the Merrimack County attorney, right?
I am an assistant county attorney in Merrimack County.
If I may proceed. Yes. Are you representing there's 9 other counties. Are you claiming to represent them, or is this your own offices or your own opinion? Where is this coming from? Where are you coming from?
So I only represent the Merrimack County Attorney's Office. As I indicated earlier, I'm an assistant county attorney in Merrimack County. I have spoken with Attorney Halverson, who is the Merrimack County attorney. He couldn't be here today, but he and I did discuss this bill at length, and we agree on the shortcomings within it.
Representative Prue.
So, in your opinion, kidnapping is a nonviolent crime?
In my opinion, kidnapping does not have an element which requires bodily injury or an imminent threat.
So I'm just going to go with you?
You can certainly read the kidnapping statute.
I think, Representative, that he's talking about the specific language in this bill versus those specific crimes.
And I mean, I can expand on that. Each crime has elements which the state has to prove beyond a reasonable doubt. So, for example, burglary, we would have to prove that the person entered the dwelling of another at night with a purpose to commit a crime therein. None of those elements require bodily injury or the imminent use of physical force. So when we look at whether or not something is a violent felony, I believe as this bill defines it, it says a felony that did not involve committing an act of violence, and an act of violence is defined as physical harm inflicted upon another individual. So the only way you would know if that crime had an act of violence, and if the jury found, or essentially the finder of fact found an act of violence beyond a reasonable doubt, would be if that act of violence were an element of the offense. And as I said earlier, burglary doesn't have an act of violence as an element of the offense. I don't believe kidnapping has an act of violence as an element of the offense. So you could certainly have a very violent kidnapping, but it doesn't have an element of the offense involving an act of violence. So in my opinion, the only way you could have a felony that involves an act of violence is it would have to be an element. Otherwise, you'd have to go back and look at the alleged facts of each individual crime and decide essentially on a case-by-case basis whether or not it was a violent crime or not. And I'm not sure how you would possibly do that.
I won't even go to arson. Thank you.
I was going to go there.
Representative Pratt.
I believe arson is charged in 2 different levels. If you ever set somebody's house on fire at night when they could be sleeping there, I believe they're charged at a higher level. And then if you set a fire to somebody's house in the daytime, it's a lower level of crime because it's assumed that people won't be sleeping in the daytime and at nighttime they are. So isn't that a felony of crime, a crime of injury or possible injury? You mentioned arson, wasn't it?
I did mention arson. And it's funny, you'd think arson would be in the index, but it never is. So arson is a property crime. Arson is 634(1). It says a person's guilty of arson if he knowingly starts a fire or causes an explosion which unlawfully damages the property of another. So there's no act of violence or threat of violence in arson. Arson's a Class A felony if the property damaged is an occupied structure and the actor knew it was occupied, or a historic structure. So again, there's no element of violence or threat of violence in that. But again, violence is defined as physical injury to a person.
Okay, I won't belabor the point. Thank you. Thank you.
Thank you for your testimony today. Chair recognizes Dr. Hannon.
Better? Thank you. Good afternoon. My name is Joseph Hannon. I'm the Vice President for Gun Owners of New Hampshire, and I'm speaking in favor of the bill. There's just for a little background, under federal law, convicted felons lose the right to firearms, and this decision stems from a 1934 law. Before that time, for over 150 years in this country, if you did the time, your rights were all restored. They handed your gun back if they took it before you went to jail, no matter what the crime was. If it was so severe that you shouldn't be out on the streets, you weren't usually released. So it wasn't even a problem or even a consideration from the founding of our country and the writing of the Constitution until 1934. In 1968, the Gun Control Act changed it to anyone convicted of a felony, whether or not it involves violence, loses their right to firearms. There's also provisions, as you've heard, to have rights restored at the federal level, and also they can be done at the state level through different mechanisms depending on the state. But we also know that the federal level has really no implementation of following through on that mechanism at the federal level that's funded, or if you try to find the phone number to call to have your rights restored, I still have not found that phone number. The federal prohibition on nonviolent criminals is not supported by the original understanding of the Second Amendment. This is a new phenomenon since 1968. There are cases in court currently. There's one out of Philadelphia. There was one in Colorado that people are trying to get their rights back for nonviolent crimes. I believe I can't remember the name of the case offhand, but the Philadelphia case, they're relying on the recent Supreme Court decision over the summer that people have a right to bear arms. But this is one of the biggest, rebuttals to that is, reasonable regulation, all these different examples of why you can have laws against everyone having a firearm. But what we don't hear about is what we should hear more of is the Supreme Court also said that it should be based on the original intent, and that was the purpose of the last several big gun rights cases that have been decided on by the Supreme Court. And the intent was obviously not to restrict the rights of nonviolent people from bearing arms. Even our own state constitution says on penalties, Article 18, I'm sure you're aware, penalties to be proportioned to the offenses. True design of punishment, all penalties to be proportioned to the nature of the offense. No wise legislature will fix the same punishment to the crimes of theft, forgery, and the like, which they do to those of murder and treason. Where the same undistinguishing severity is exerted against all offenses, the people are led to forget the real distinction of the crimes themselves and to commit the most flagrant as with little compunction as they do the lightest offenses. So, is a nonviolent crime of writing a bad check 30 years ago or, food stamp fraud, 10, 20 years ago, is that something that's worth depriving someone the right to defend their lives and the lives of their loved ones? I don't believe it is. I think that is definitely not proportioned to the crime. And to have a blanket law that says you can't have your rights that are inherent rights, I think is absolutely wrong. I don't want to go too long because I said I would only be a couple minutes, but a few little things about the bill as far as specifics. There is a except that says it shouldn't apply to U.S. Marshals, sheriffs, police, or other law enforcement officers, bailiffs, court officers, etc. So we're creating a special class of citizens. Again, it's already in the law. A lot of these laws don't apply to those people. But if you have an officer who is allowed to keep their job, or a military person who was convicted of a felony, inducted into the service, they're serving their time, they could be walking around with a rifle on active duty in New Hampshire, and that's totally legal. So we've created we've created different classes of citizens and how they're to be treated in New Hampshire with firearms laws. And there was a comment made about, violent drug laws, and I asked myself, if someone who's purchased or used or tries to sell the drug, ethanol, is that person a violent criminal? If they are, I think we have a lot of questions to ask our own state for selling it on street corners all throughout the state. So just by the inherent fact that someone is using a drug, sold it, or possessed it, the only distinction is licit versus illicit drugs. And that is something that is being debated in other bills and laws around the country. And from personal experience, I can tell you I've never been assaulted by someone who was on cannabis. I know this is not a cannabis bill, but I've never been assaulted by someone who was on cannabis in a bar. It's usually someone drunk, gets beer muscles, and they get all into full themselves. So I don't think we should draw those distinctions on our own perceived biases towards different substances, because I'm not going to ask it for a show of hands, but you know, if you raised your hand, if you drank alcohol, you may be a violent criminal. So I'm happy to take any questions.
What is the position of the organization on, we were talking about felonies, but isn't it also true that any misdemeanor where you could spend up to a year in prison triggers a federal bar to possession of firearms?
We'd be very happy for an amendment to extend it to all those also. If someone is not convicted of violence, or if someone is not a violent person, why should that right be taken away? And in this state, it is not decided necessarily on a case-by-case basis. If you've been convicted, you are automatically denied that right beyond the terms of your punishment and debt to society. You know, I heard growing up, you do the crime, do the time, but also you paid your debt to society. When does that happen? Apparently, death is when it happens.
So just to follow up, an OUI conviction,
A what?
an OU,
Yeah,
driving under
yeah.
the influence conviction, you can lose your right to carry firearms because of the potential penalty.
Absolutely.
Is that accurate? Yeah.
Yeah. Thank you.
Representative Newman.
I just have a follow-up to your question. What about a DUI or OUI conviction that caused injuries? Is that a violent felony? And that gets to, is there a good definition either in New Hampshire or federal law of that?
I think it is addressed in the language of the bill. In this paragraph, an act of violence means attempting to cause or purposefully or recklessly causing bodily injury or serious bodily injury with or without a deadly weapon. So I believe that would be covered if someone is seriously injured. Whether I agree with it or not, I don't want to say, because I don't know the specifics of any individual case. But if someone is injured by this, I would read it as they would be prohibited and not exempt under this bill.
Thank you. I think that covers, if this
Thank
bill
you.
becomes law, that would be the definition then.
Thank you.
Thank you.
The chair calls Ian Freeman.
Thank you for listening here. I do support this bill, although I don't think it goes far enough. The fact is, there's the reality, and then there's what the law says. And the reality is, if a violent person gets out of prison after being convicted for a violent crime, and that violent person wants to go and get themselves a gun, it doesn't matter what the law says. They're going to be able to get a gun. Where there's a will, there's a way. And if they want to go and commit another violent act, they're going to do that. They don't care what the law says. By definition, that kind of person doesn't care about what the law says. They've proven that by the fact that they violated it in the first place. So really what these prohibitions on felons owning guns or possessing guns prohibits is the people who've tried to turn their lives around. The people who maybe they did something wrong when they were in their teens or their 20s, and then they spent some time in prison, and then they got a family together and they started their own business, or, you know, whatever the story is. They've turned their lives around. They haven't recidivized. They haven't committed another act. They are now a valuable member of society, but they're prohibited because of a mistake they made in their past from being able to protect their families and themselves. And the New Hampshire Constitution is very clear when it says that all persons have the right to keep and bear arms in defense of themselves, their families, their property, and the state. It doesn't say, with the exception of if the legislature doesn't like them. So, like I said, I support the bill, but I think that quote-unquote violent felons do not all go on to commit more violence, and they should also be included in this legislation. Because they're humans too.
Thank you. I don't see any questions. Thank you, Mr. Freeman. Is there anyone else wishing to testify who has not testified on this bill? Seeing none, I close the public hearing. What's next? Does it do right now?
I think this crowd is here for the blackjacks.
Okay. At this time, I'll open the public hearing on HB 31 and recognize Representative Spillane to introduce this bill.
Thank you, Mr. Chair, members of the committee. Thank you for allowing me to introduce this bill. I am Representative James Spillane, representing Deerfield, Candia, and Auburn. Based on what I've heard, I hope this one's a lot simpler than what you've been going through. HB 31 is looking to repeal two RSAs, RSA 159.16 and RSA 159.17, which trails colon 16 and is tied to it. RSA 159.16 prohibits people from owning or selling blackjacks, slingshots, and metallic knuckles, brass knuckles. There's no reason to have a prohibition on these items anymore. We allowed knives of any length to be legal in New Hampshire over 12 years ago. We have people able to carry firearms for self-defense, and the truth is that blackjacks, slingshots, and brass knuckles are purely non-lethal defense weapons, tools to be used to protect yourself. And quite frequently, let me define what a slingshot is, because most people don't know what it is. It's essentially just a weighted stone or a ball on the end of a braided rope. And quite often, those are sold as monkey fists, and they're carried on keychains. Quite often, women will carry these to be able to offer some form of self-defense if they're assaulted when they're walking alone. Blackjack is the same sort of thing, except that it's a leather strap with a weight in one end. And these strictly non-lethal, antiquated methods of self-defense should not be prohibited from an option for somebody in addition to being able to carry a knife or pepper spray or what have you. If I go to the actual statute, because it wasn't included in the bill, and I think that it's important to also hear how it's written. 159.16 says that whoever, except as provided by the laws of this state, sells, has in his possession with intent to sell, or carries on his person any blackjack, slingshot, or metallic knuckles, shall be guilty of a misdemeanor, and such weapon or articles so carried by him shall be confiscated to the use of the state. What the state's going to use it for, I have no idea, but the state can go around collecting them, confiscating them, and then using them. The reason I've also asked to repeal colon 17 is because 17 basically says the provisions of the preceding section, all of 16, shall not apply to officers of the law, to persons holding hunting or fishing licenses when lawfully engaged in hunting or fishing, which is how I became aware of this as the chairman of Fishing Game, to employees of express companies while on duty, to watchmen while on duty, to emergency medical technicians, firefighters, military personnel while in the course of their duties, or to duly authorized military or civic organizations when parading, or to the members thereof, goes on. There's a whole lot of people that are allowed to carry this and exempted from the previous section, but it's such a poorly written bill that when they put this exception in, it accepted the entire first paragraph, which also included selling. So you've essentially said that all of these people listed here can sell blackjacks, slingshots, and brass knuckles. So police officers could open little boutiques in the back trunk of the car and sell brass knuckles, slingshots, and blackjacks out of the back of the trunk of their car. A hunter in his tree stand could open up a briefcase and open up a little shop and sell them. Perfectly legal, because this is so poorly written that the second paragraph exempts the entire first paragraph for this group of people, and it's just a shambles. So I'm asking you to repeal both of them. They are widely in use in the state. This prohibition is not enforced, except maybe as a secondary offense if they stop somebody for some other offense and they say, oh, we can also add on another charge because they're carrying that. One more thing I'll add before I finish and take questions. You can go through the airport and TSA will not take a monkey fist off your keychain or a blackjack off your keychain if you're carrying one. It's not considered a lethal weapon and they don't care if you carry it on a plane. If TSA is not going to prevent us from carrying those on a plane, why are we saying that you can't carry them around for your self-defense when you're walking to a dark parking garage in the middle of the night? Thank you.
Representative Sitek.
When you read that list of the original bill, original law, you said possession with intent to sell. Is it possible to just outright own it?
No, it says whoever, except as provided by the laws of the state, sells, has in his possession with intent to sell, or carries on his person.
What prohibits just outright ownership in that?
Carries on his person. Technically, I suppose you could own it in your house, and frequently we've seen, I mean, growing up, I've been in New Hampshire all my life, and you could go down to the local 5 and 10 shop and you'd see brass knuckles for sale, and they would say they're paperweights. And right now you can go onto Amazon and buy a blackjack, and it's called a book weight because it's a leather strap that has a weight on the end that holds your book open, but it's a blackjack. And a monkey fist is just a steel bell bearing inside a braided paracord that's hung on your keychain, and it's considered technically a slingshot. But it offers somebody, just like wrapping your keychain up and having a key ready in case you get assaulted, it offers you something easy at hand while you're walking to your car that you can use to defend yourself so you can run away. It's a non-lethal tool.
Thank you.
Thank you.
Chair recognizes Representative Hall.
Thank you, Chairman. Representative Hall, Dunbarton, here on behalf of the New Hampshire Firearms Coalition. The New Hampshire Firearms Coalition is a 501c4 nonprofit representing the gun owners in the state. And although this bill has almost nothing to do with the gun owners directly, it has to do with something called possessionary offenses. And in this case, it's possessionary offenses of self-defense tools from the early 1900s, right? Today, people would carry mace with them or pepper spray. That would be the most common non-lethal tool that someone would carry with them if they wanted to protect themselves. That has supplanted most of the ones on this list. These are now collector's items. Let's call them what they are. These are things that go in museums for the most part. So because it's a possessionary offense, and possessionary offenses, it's not what the tool is, it's how the tool is used. Murder is a crime because you've used something, what, baseball bat, axe, firearm, doesn't matter, whatever, and you've harmed someone. That's a crime. We definitely have laws that prohibit crimes, and we do things about crimes. But the mere possession of something should never be an offense unless it's part of a part of the evidence of a criminal activity, right? I have a stolen good. That's a different story. So we would ask that you would pass this because we leave these laws on our books that really aren't enforced. That, as the prior member said, right, he wants to buy a paperweight to hold his book open, and it just happens to be sold as something else. They do sell knives that happen to have a series of finger holds built into the hilt that potentially, under an overzealous prosecutor, could be prosecuted for one of these laws type thing. And all it is a better way to hold on to the knife. So with that, I would ask the New Hampshire Firearms Coalition as an organization supports the repeal because this law is antiquated, and it really has to do with effectively collector's item self-defense tools. Thank you.
Thank you. Thank you. The chair recognizes Frank Staples.
I'll be brief. I live in a horrible neighborhood in Manchester, New Hampshire, and as I showed you earlier, I have a knife. A knife is actually more deadly than a gun. If I was to stab somebody with this, it's over with. I would prefer not to have to do that and be able to use something like a club, a blackjack, a sap, or some metallic knuckles. Not only would it keep me from likely killing this person and causing, the ambulance and all that But it would protect my hands as well. So anyone who has to use their hands for a living, whether it's typing or doing any work, that would allow people to protect their hands if they ever did have to defend themselves in a situation like this. And I mean, it's absurd. I'm allowed to have a sword on my hip and all these knives, but at any length, but I can't have a little blackjack or a monkey fist or something like that. It's pretty crazy. And like J.R. Hull said, there's already crimes. If you assault somebody with a pen, it's assault with a deadly weapon. If you assault somebody with a rock, it's assault with. If you assault somebody with a sap, a blackjack, unprovoked, it's not self-defense, then it is assault, unprovoked assault. So we already have crimes, and I think I'm being redundant at this point. Thank you.
Thank you.
No questions?
Oh, I'm sorry. Representative Newman.
Yes, Mr. Staples, sorry. Mr. Staples, I think, I'm not sure if you just said it or the previous representative, but I just kind of quick looked while there was testimony going on. Brass knuckles could be carried on and could get through TSA, but they would have to be in a checked bag.
Check thing.
And I think there have been instances when TSA has confiscated, whatever you want to call them, a brass monkey thing or whatever.
Sure.
Check bags. Do I have a question? Yes. Do you agree with what I just said?
I mean, I know that they sell on eBay. They sell like bulk things that have been confiscated by TSA that people never came back to claim. So I'm sure there's probably, I've never purchased a thing like that, but I'm sure they confiscate things and make mistakes. Like these, I think the problem that we have here is there are just too many redundant laws that aren't really doing anything except causing a lot of confusion. You know, we have these assault laws. Somebody assaults somebody, it's assault, whether it's with a weapon or without a weapon. And the weapon could be anything. It could be this Clorox thing. Like, all right, thank you.
Dr. Hannon.
Hello again. Oh, it's on. Good. Joe Hannon from Gun Owners of New Hampshire. Like Representative Hull said, I'm from a gun organization in New Hampshire, but this is relevant because it has to do with any kind of arm or possession case. I actually had to look up some of the terms. Obviously, I know what brass knuckles are. I know what a blackjack is, but a slungshot, I just wasn't sure exactly, so I looked it up and I was like, oh yeah, I know what that is. But historically, it was actually used for maritime reasons. It was a way to fix to a long cord to be used to cast a line from one location to another, which explains why in the current statute it's one of the exceptions to carry any of these items during hunting or fishing if you have a valid license and you're doing that activity. So it's okay to have it, I guess, if you're doing that, but I don't really see a way how you can buy it or sell it unless you happen to see someone else hunting or fishing and happens to have a blackjack, or whatever, brass knuckles with them or slugshot, and you can buy it while you're both hunting and fishing, or they're a law enforcement officer or any other one of these other exceptions. So I do believe that a lot of these things are not even going to be really used at all for even self-defense purposes, as there are far better ways of doing it. You don't even need a permit to carry a firearm in New Hampshire if you're legally allowed to obtain a firearm. That's a pretty, superior method of self-defense. But not everyone can afford hundreds of dollars for a firearm. So if someone is poor, this is actually something that disadvantages people that can't afford $400 or $500 just to defend themselves. The law also talks about, and I'm sure this is, just semantic, but has in his possession with intent to sell. I guess women are allowed to have these things. It doesn't say anything about her. It just says his. So I don't know. Maybe just I'm reading too much into it. But interestingly enough, it says if someone's convicted or someone has these items, it's a misdemeanor. But if any such weapon or articles is carried by him, not hers, it shall be confiscated to the use of the state. So I guess the state really needs brass knuckles, slug shots, and monkey fists, or all these items because this is how we're going to get them. So I don't think this is a really important law to keep on our books. I think it's superficial and actually a silly law to keep, considering all the other laws that we currently have. Thank you.
Representative Gerhard.
Thank you, Chairman, members of the committee. I'll make this super fast. Representative Gerhard, Northfield Franklin. I just want to support this bill and to address what you said earlier about TSA and brass knuckles. I know that you can have belt buckles with brass knuckles on them, so I'm pretty sure that would get passed if you wanted. So, and just curiosity's sake, did anyone file opposition to this bill? No? Okay, just curious. All right, thank you very much.
Anyone else wishing to testify on this bill who has not testified? There's being none, I hereby close the public hearing.